You have to wait till tomorrow. Tomorrow I'll pass on.
May I give a citation if possible or not?
Yes, Liming.
Okay.
Please, Lordship, with the humble permission, item number 44 is the hearing, only 2 cases. So, my lord, it may be taken at 2 p.m. because the number of time is listed
No.
because of paucity of time of this court.
Hearing matter.
That is why, my lord, this is a maximum 20-30 minutes.
No. You have to wait till your turn.
Because number of days, my lord, listed before this only court because of.
But we are helpless.
Although, my lord, possibility may be his own matter, my lord. Because last time also remanded in the lower court has made some error in the judgment. That is why.
Item number?
Item number 44, ma'am. Both the side is my lord.
We'll see whether we can take it up as last item.
Much.
Item number 16, for 11, I've already found an affidavit, so let it be come on record, my lord.
Okay.
May I please, your lordship. Your lordship, I beg to mention item number 22 of today's daily list. Mrs. F. Begum, the contending counsel, was about to appear, your lordship, but she felt ill last night. So kindly the matter be adjourned. I have taken the consent of the other side, your lordship.
What is your name?
S. Paul, your lordship.
Heard Mr. S. Paul, learned counsel for the appellant, who prays for an adjournment on the ground that the conducting counsel for the appellant is indisposed. He submits that he has informed the learned counsel for the other side regarding it. You are there?
Yes, my lord. I am appearing on behalf of OS Money.
Miss, what is your name? Miss M. Begum, learned counsel for the respondent side, does not oppose the prayer. Hence, the prayer is allowed.
Clarification.
It will be listed by registry.
So with regard to item number 16, we need some accommodation to file our affidavit of paper publication.
Affidavit against?
Paper publication. Publication has been done.
Okay. Item number?
16.
Heard Mr. SP Sharma, learned counsel for the appellant, who seeks some time to file an affidavit in compliance regarding publication of the notice in newspaper in pursuant to this court's order. The prayer is allowed. Let this matter be listed after 2 weeks.
Obliged.
Item 8 and 9. Item number 8 and 9.
We'll take it up after something.
Item 10. Item number 10.
May I please, lordship. The arguing counsel is busy on the court, so I'm playing for adjournment.
Adjournment for day
Yes, ma'am.
89. What is your name?
A.
What is your name?
A.
Mr. Heard Mr. A. Tete, learned counsel appearing for the petitioner.
Item 8.
Item number 8. Who? No, we'll take it up after some time. Bail cancellation is there. We'll take it up after some time. No adjournment.
Yes,
If let her come.
yes.
Item 10. Item 11.
At 11. My lord, I just now I filed an affidavit, my lord, that it should be on record, my lord.
Item 11,
11 and 11, then 10, 10, 11. Yes, item number 11, my lord. I just filed an affidavit.
where have you filed? In the filing counter?
The filing counter, it should be on record because I have an interim bail, my lord. So I was directed to submit an affidavit that I was undergoing a hospital treatment operation. So already I was operated, now I'm on rest. So during this time I have to surrender. So I could not surrender because I have eaten and suffering from chicken pox. So if you lordship take, you can take up on merit also, no problem.
Where is your affidavit? It would take corresponding. Let the affidavit
Yes.
bring the affidavit on. Let it come. We'll take it up after some time.
Well, probably it was fixed for inspection of service.
We have served, taken
is
steps to
completed.
service to the respondent number 2.
It has been completed.
Service of-
Service is complete.
CD is also available.
74 days behind the bar, my lord, not yet charge sheeted.
The oximeter,
Yes, section 6 is there.
then an amicus has to be appointed. Heard Mr. D. Vishwas. Sorry, S.C. Vishwas, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that the notice issued to respondent number 2 has been duly served. However, no one has appeared for the respondent number 2. Hence, this court is inclined to appoint, and any amicus present in the court, this court is inclined to appoint one, suggest one name, Mr. Sharma. This court is inclined to appoint one amicus curiae to defend the cause of respondent number 2 in this case. Accordingly, Mr. T. Gogoi, learned counsel, Mr. D. Gogoi, learned counsel, whose name appears in the list of amicus prepared by registry of this court, is hereby appointed as amicus curiae in this case to defend the cause of respondent number 2. The petitioner is directed to furnish a copy of bail application along with annexures to the respondent number 2 within 2 days. Within 2 days from the date of this order. Phone number is available with the within 2 days from the date of this order. The registry is directed to reflect the name of Mr. D. Gogoi as amicus curiae for respondent number 2 in the cause list henceforth. List this matter
Friday if possible,
Friday.
if possible.
Okay.
Then Lordship will-
Friday is
Question.
on, list this matter on 12th.
Lordship, let them serve the copy during the
Sure.
course of the day.
They have, within 2 days we will serve.
Not within 2 days.
Today itself.
Today
will
itself.
have.
During the course of the day. The case diary which is available shall be retained till next day.
Your Lordship fixing it Thursday.
12th.
I am pardon.
May I please, Lordship? Well, the 483 resolution, my lord, already 90 days, 96 days over, my lord. Statutory means over, Lordship.
He was arrested on 4/9/24.
Heard Mr. B. Islam, learned counsel. Counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, as well as Mr. A. Alam appearing for respondent number 2. This application under section 483 of BNSS
Earlier
2023.
Earlier rejection order is there.
Okay. Has been filed. Case diary is there. Charge sheet has not been filed. Has been filed by the petitioner Abdul Razak alias Razak Ali, who has been detained behind the bars since 3/9/2025 within bracket for last 93 days, 96 days, bracket close, in connection with Mayong PS case number 105/2024 under section 61 within bracket 2/10142 of BNS, read with section 6 of the POCSO Act 2012. This is for the second time the petitioner is approaching this court seeking bail. His prayer for bail on the earlier occasion was rejected by this court by order dated
26/9/25.
26/9/2025 in bail application number
1972 of 25.
1972/25. The petitioner, learned counsel for the petitioner submits that the petitioner has been detained behind the bars for last 96 days. He has completed the maximum statutory period of detention during the investigation period, and hence he is entitled to get bail on that ground. Learned additional public prosecutor also endorsed the fact that he has completed this maximum statutory period of detention during investigation. Considering the above facts and circumstances, the petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned special judge, which is the court, Morigaon.
Mayong.
Learned special judge, Morigaon. With following conditions, condition number 1 and 2. This bail application is accordingly disposed of. Send back the case diary.
Item 1. One, na? Learning ke liye. Order 1. Order 1. Order, last order. My lord, it was heard by your lordship, my lord, and your lordship kindly see the last order, my lord. Last but one order, my lord. Order is 17 feet with a 25.
Order dated
No, sir, probably 7/9. Last date is 7/9. Oh, 7, no? Number of it. 28/10, sorry, my lord, 28/10. 28/10. Heard Mr. T.J. Mohanty, learned senior counsel, Assistant P. Gogoi, learned counsel to the petitioner also heard Mr. S. After, learned counsel appearing on behalf of the respondent. During the course of the hearing, a query was posted in whether the impugn order is justifying invoking superintendent power of the High Court under Article 227 of the Constitution, when Elma says they did not consider the plea agreement made by the learned counsel or the defendant before the trial court. The proposed amendment would change the nature and character of the suit without considering the said submission. It allow the amendment of the application. On this, the learned counsel appearing on behalf of the respondent pays for a time to answer the query and show the authority and support of his submission. Did this case be shown? So in that my case, my case is listed, my lord.
brief facts. What were the facts?
My facts is that my
Some amendment was allowed.
amendment, but I have had a specific plea. I have written a specific plea that this amendment is allowed and it will be change the nature and character of the suit. All right.
They are not giving any finding on that. That's why on that ground, my lord, because it is a duty, when I raise a question, it has to be answered by the trial court. That has to be adjudicated, my lord. But nothing, not a single line, my lord. My lord, they allowed a petition because it is filing time. That is the only count. So that's why in that context, I prepared a petition, honorable court, and that was already been stated, my lord. So, and it was heard by, on that occasion, my lord, he was asked that whether it can be done on. And he was asked to any authority and he has put place, my lord. So that is,
Yes.
My lord, the brief fact of the case is that the suit was filed for a specific performance of contract. The predecessor in interest of the present petitioner, my lord, he entered into an agreement, registered agreement for sale of 7 bigha, 1 kattha, 17 lecha of land, my lord, to the tune of rupees 50 lakhs. Out of that, my lord, 48 lakhs was paid and the agreement was registered. What was remained to be paid was only rupees 2 lakhs for the purpose of execution of the sale deed. Now, my lord, meanwhile, the predecessor in interest of the present petitioners, my lord, he expired on, my lord, 24/6/2023. 24/6/2023.
The agreement
I
was between,
dispatched. No, he expired in the year 2021 on 25/2021, and thereafter, when I requested the the present petitioners for execution of the sale deed, my lord, then they refused and they forcefully dispatched me from that premises. My lord, my suit was filed on 27/4/2023. This is most important date.
27.
4/2023, my lord. It was in the month of April. The date was 27, my lord. Year 23. During the course of pendency of the suit, my lord, I was dispossessed on 24/6/2023.
Yes.
Then I brought that amendment. Filed an application for amendment of the plaint, seeking inter alia, my lord, that though I was in possession, but during the course of the pendency of the suit, I have been dispossessed. And that prayer is required to be inserted in the prayer portion, as well as, my lord, a little about who dispossessed me. So I have already mentioned in para number 6 of my amendment application, my lord. If your lordship pleases to go through that paragraph, I can take the honorable court to that. That, my lord, page number 45. Page number 45, para 6, my lord. Of the memo of revision application, my lord.
That
Yeah.
is the proposed amendment.
That the proposed amendment to the plaint of title suit number 11/2023 is as follows. May I read, my lord, that part? That at the end of paragraph number 6 of the plaint.
No, okay.
So my
That
lord-
means you intended to bring the fact of your disposition
My lord,
in the plain.
yes, my lord. And the suit will remain as the suit for a specific performance of contract, even if this date is brought to the, the plaint, my lord. It will not change the nature and character of the suit. The suit will remain as the suit for a specific performance of contract. And my lord, if I can say little more to that, my lord, say for example, my lord, an agreement for a specific performance of contract is entered into and possession is not handed over to me. I am not in possession of. Can I not pray, my lord, for putting me into the position on the grant of the decree under order 20 rule 18, my lord?
After execution of the sale deed.
No, my lord. If the sale deed is not executed and I have filed the suit for a specific performance of contract, my only prayer is that I am still ready and willing to purchase the property by paying the remaining amount. And as I was not given the position of, after the passing of the decree, at the time of execution, I must be put into position. That is the prayer consequential to that, my lord. Consequential to that, because when the person fails to execute the sale deed, save and accept the prayer for a specific performance of contract, there is nothing with me. I have already parted with rupees 48 lakhs, my lord, out of the consideration
Not a
amount of.
single money paid, my lord. What mode of
Oh, that
payment they
will
have
be-
not been mentioned. That is why, my lord, the crux of the matter is this, my lord. Not a single penny has been paid, my lord. On what mood? My lord, very basic question is that on what mood they have made payment? The mood of either by bank grant, either bank amount, check or cash, nowhere mentioned. I am not
We
on that.
will not go into those.
I'm not going into that, my lord. My submission, my lord, sorry.
My lord, the negotiation with the predecessor in interest of the present petitioner, Mr. Hiteshwar Saikia, was done on 12/2/2021. 12/2/2001. After taking the amount, he got this agreement for sale registered, my lord, on 18/2/2021. At that time, he was very much alive. They cannot say that whether I have paid the money or not, because I have paid the money to the predecessor in interest of the present petitioners, and he has received the money. Only thereafter the sale, this agreement for sale was registered. It is a registered agreement for sale, my lord.
Okay, by the impugn order, your prayer for amendment was allowed.
Allowed.
Now they have challenged it.
That as that my prayer is allowed, it will change the nature and character of the shoot. And I am on that point only, my lord.
No, their plea is that the trial court did not take into consideration their submission that it will change the nature and character of this. suit. And
the-
no finding was
Yes,
given.
I do admit, my lord, in the finding portion, this part is not mentioned, that it will not change the nature and character of the shoot.
Yes, therefore, whether such a order can be challenged under 227.
Yes, my lord, for that purpose, I would like to apprise your lordship. There is a decision of the Supreme Court, my lord. Regarding the other day, your lordship had to ask me whether, what is the supervisory jurisdiction of this honorable court?
Shalini Shyam,
Yes,
yes.
para 41, 42, 61, 62, my lord. Para 41 is appearing at internal page 10 of the judgment, my lord. 19-page judgment. Para 41, my
Yes.
lord. In para 14, page 217 of Variam Singh Supra, this court need, my lord, many cases are discussed, my lord, here. Nearly formulated the ambit of the High Court's power under Article 227 in the following words. The power of superintendence conferred by Article 227 is, as pointed out by Harris Chief Justice in Dalmia Jain Airways versus so and so, 1951, Calcutta 193, to be exercised most aspiringly and only in appropriate cases in order to keep the subordinate courts within the bounds of their authority and not for correcting mere errors. Thereafter, my lord, para 42, the Chief Justice Harris in a full bench decision in Dalmia versus so and so stated the principles on which the High Court can exercise its power under Article 227 very succinctly, which we would better quote. All these are, my lord. The only question raised is as to the nature of the power of superintendence conferred by the Article 6. Though this court has a right to interfere with decisions of courts and tribunals under its power of superintendence, it appears to me that right must be exercised most aspiringly and only in appropriate cases. The matter was considered by a bench of this court in Manmathan versus Emperor, AIR 1933, Calcutta 132. In that case, a bench over which Sir George Rankin presided held that Section 107 Government of India Act, which roughly corresponds to Article 227 of the Constitution, does not vest the High Court with limitless power, which may be exercised at the court's discretion to remove the hardship of particular decision. The power of superintendence it confers is a power of a known as well as recognized character and should be exercised on those judicial principles which give it in character. In general words, the High Court's power of superintendence is a power to keep subordinate courts within the bounds of their authority, to see that they do what their duty requires and that they do it in a legal manner. My lord, here, even if that word that it will not change the nature and character of the shoot is not mentioned, that does not mean that going to cause any prejudice to the opposite party. And no perversity is also done. Because mentioning of that word, my lord, in the order,
If it is otherwise not changing the nature and character.
yes. Yes. my lord.
Okay.
Now paragraph number 61, if it is required to be read, I will read, my lord, otherwise I don't want to.
No, it's. He is, anything else?
No, my lord, that much only, because that was the query by this honorable court to me, that whether I do have the power, supervisory power to.
Any clarification? That mere errors cannot be rectified.
No, that is not mere error, my lord. There is no discussion and finding. When I raise a question, then that means, my lord, then a trial court will do nothing, my lord. When, my lord, it is, I have placed, my lord, how it is, my lord, the change in nature and character. I have everything placed. That should have been discussed, my lord. No discussion, no finding. If, my lord, when a query made by the, before the trial court, if no findings, no discussion is that is definitely, my lord, court has the power to interfere. And that is the mandate. In fact, the judgment which was placed before your lordship, it is an in fact in, my lord, my favor, my lord. Yes, that 2026 power cannot be springly, my lord, springly it will be applicable, my lord. But it is a discretionary power. It can be exercised when, my lord, case to case basis. When there is a totally ignoring the law, my lord. But here, my lord, your lordship can list. That means the way why the amendment petition is allowed, just because it is within the 5 time, that is it is allowed. Can it be a ground, my lord? We have in the objection petition, we have clearly objected that it is a entire, my lord, nature and character has been changed. We going to be changed, my lord.
Okay.
So that's why, my lord, your lordship kindly remand the matter and hear it again, my lord, because that discussion has to be there, my lord. Otherwise, my lord, there is no question, my lord, any objection, my lord. Then within time, all will be allowed. If it is filed within time, all, my lord, amendment petition will be allowed, my lord.
My lord.
Your lordship kindly see the finding, my lord. That only, my lord, is
let
within
my
time,
learned
that's why
friend
it is.
finish it, then I will take the honorable court to the paragraph number 7 of his objection, which was made while me filing the petition on order 6. My lord, para number 85, this page number 85. Because it is a very short objection, but only in para number 7, which is at page number 85,
85.
my lord.
That it will change the nature from.
Yes, it is submitted that
Specific.
the present suit of the plaintiff is a suit for a specific performance of contract. But if the proposed amendment is allowed, that will change the nature and character of the suit from a suit for a specific performance of contract to a suit for eviction of the defendants. My lord, eviction of the defendant, how it has come? Only when I was dispossessed during the pendency of the suit. And it will never change it, the nature and character of the suit.
Yes.
Okay. Heard Mr. T.J. Mahanta, learned senior counsel, assisted by Mr. A. Borua. Also heard Mr. A. Sattar, learned counsel for the respondent. Let this matter be fixed for delivery of judgment orders on 15th of December. On 15th December.
Version of 2019, my lord. Your lordship kindly 2019, my lord, I'll give a copy, my lord. I have relied on 2 judgment, I'll give you the copy, my lord. Photocopy by today.
Judgment with paragraphs.
Yes, judgment with definitely. Judgment with paragraph, my lord. No, only one on paragraph, my lord. In both the judgment.
Okay, on
I'll give a photocopy, I'll give it.
okay, on 15th I will pass
My lord,
delivery.
diploma.
Lordship, may kindly peruse office note dated 27/11/2025. An IA filed by me was called for, now it is notified, it has come on record that there was some defect. Well, what has happened at the time of filing the I was not the engaged counsel. Even if it was notified, I was not aware of it. So if your lordship may grant me 2 weeks time, let the matter be listed after 2 weeks. I'll rectify the objections, whatever is there, madam.
Heard Mr. D.
D. Goswami.
Goswami, learned counsel for the petitioner. On perusal of the office note dated 27/11/2025, it appears that the interlocutory application filed by the present petitioner has been found defective and lying in the filing section since long. Learned counsel for the petitioner submits that he may be granted 2 weeks' time to rectify the defect in the said interlocutory application, so that the said interlocutory application may be taken up along with this CRPIO. The prayer is allowed. Let this matter be listed after 2 weeks.
I can remove passerby for time being, your lordship.
Well, I have no objection, that is other thing. I'm also suffering from some illness. Any other date may be.
Senior Advocate RC Shakya is there, so he's coming.
It
Who
was
is-
fixed on Friday.
Who is there?
RC Shakya, sir, senior advocate, so he's coming just for
No.
time being, let time being.
It may be fixed on Friday, madam. I'm also suffering from illness.
Heard Mr. B. Hussain, learned counsel for the petitioner. Also heard Mr.
JP Burua on behalf of. RC
JP
Shakya.
Burua appearing. JP Burua, learned counsel for the respondent. Learned counsel for the petitioner has prayed for an adjournment on the ground that he is not well today. Considering the submissions, the prayer is allowed. When? Next week,
1 minute of the.
Date will be fixed.
after?
1 minute.
Let this matter be listed after 1 week.
The date may be fixed, your lordship.
No dates.
May I appeal the lordship?
Yes.
Lordship, in this matter, I was supposed to obtain instruction regarding the dismissal of the title suit, lordship. There is an order of 3/11/2025.
Yes, whether it is still pending,
Lordship, it has been dismissed for default, lordship, and accordingly a restoration petition has been filed. That is the instruction that I have, lordship.
then whether this
Lordship, the date is fixed on 10th or 11, lordship. If lordship fix this matter after the vacation, lordship. And in the meantime, if it is restored,
okay, heard Miss F. Ahmed, learned counsel for the petitioner, who submits that she has been informed that title suit number 54/2021 was dismissed for default by the Court of Learned Civil Judge Karimganj, and accordingly the plaintiff has filed a restoration application. She submits that the said restoration petition is fixed for hearing in the
month of December,
in the
lordship.
month of
10 to 11
in the
time.
month of December. Hence, she prays for listing this matter in the month of January,
Lordship.
so that if the title suit is restored, this matter may be pursued or some other decision may be taken according to fate of the restoration petition filed by the plaintiff. The prayer is allowed. Let this matter be listed in the month of January
Deeply
2026.
May it please your lordship. My lord, in this matter, a scan copy of one record will be required, my lord.
Which record?
My lord, it will be title suit number 79 of 2022.
What is the issue here?
Issue, my lord, is like this, my lord. My lord, the petitioner, my lord, as they had around 3 bighas of land, 3 bighas of land, the petitioners, my lord. And my lord, in the neighboring plot, the one Mohit Roy had around 15 bighas of land. So our case was that, my lord, after the death of Mohit Rai, his legal heirs encroached around 1 katha from our land. And they were in talks with some other party to sell that land, including our land. So we instituted a suit, filed a suit. That is title suit number 72 of 2022 for declaration and recovery of possession. In that suit, my lord, injunction was granted against the legal heirs of Mohit Rai along with the third party. Injunction was granted.
Okay.
So I am pressing for calling of that record, madam. Subsequently, what happened? This third party, they institute some kind of collusive suit against the legal heirs of Mohit Rai for specific performance. And there they got a decree by admission because the legal heirs of Mohit Rai, they came and admitted the suit filed by the third party, saying that they are willing to hand over the possession and also execute the registered deed. So they obtained a decree. So that record has already been called for. That record is there, scan copy.
Now, what is impugned in this case?
Impugned is that, well, what happened after the decree was passed. If your lordship will kindly see page number 87. 87. This is the decree which was passed in the second suit. That is the suit filed by the third party against the legal heirs of Mohit Rai. Page number 87.
Yes.
If your lordship will kindly come to the next page. Last third line from the bottom. The sub-register Bongaigaon is directed to register a sale deed executed and presented by the defendants in favor of the plaintiffs.
Yes.
So the court directed the sub-register to,
This is the impugned order.
I'm coming there. I mean,
Okay.
this is the decree. We have challenged the decree by filing a separate suit that this decree was obtained by fraud.
Collusive decree.
Yes, we have filed a suit. Now subsequently what happened after the decree was passed, the plaintiffs in the second suit, they again filed a petition under 152, praying for modification of the order, saying that it ought to have been the sub-register Bizni, not sub-register Bongaigaon. This petition lords will find at page number 104, after the judgment was passed. 104. 150, this is the petition under 152.
Okay, then what
this-
happened?
This petition was allowed. Lords will kindly see page number 112.
Okay,
This
then,
petition was allowed.
then what?
And the court modified the decree to the extent that it will be sub-register
Disney.
not Bongaigaon.
Okay,
Then again they filed a petition. This is the second petition under page number 114. Now they are saying that no, it's not sub-register Disney, but it should have been sub-register Bongaigaon. At page number 114. Thereafter, the trial court went on to make an inquiry, calling for a report from the circle officer to verify as to whether the suit lands fell within his jurisdiction or within the jurisdiction of Disney. That my lord will find at page number 119. Page number 119 and relevant portion is at page number 120.
yes, then what happened?
Thereafter, the circle officer submitted a report at page number 121. Then at page number 122, again the judgment was modified.
So again.
Again it was
Bongaigaon.
So our contention was that
Which is the impugned order?
all these three orders after the judgment was passed, that once the civil court passes a judgment, it becomes a functus officio matter. It does not have any jurisdiction. But what happened in this case, the court went on to make inquiry, brought changes into its original decree. And 152 is only for correcting any clerical or arithmetic error. The court cannot go on making an inquiry after inquiry, taking petitions, changing.
So this is the issue in this. yeah.
Yes, yes. That's what we are.
Then why this 72?
Because the injunction order is there in that case.
But how it is related?
Because that injunction prohibits them to make any changes or alienate the suit land, because in that case, my lord, the suit land is within the 15 bighas of
No,
land.
but the question is whether the changing of the designation of circle officer from Bongaigaon to Bizni and again to Bizni to Bongaigaon is within the purview of
That lordship will have
section
to examine.
152.
Yes.
That
lordship
is
will
the
have-
only question.
Yes,
For examining that question, whether records are necessary.
because that also includes our land. And the injunction order is also relevant, my lord, because the injunction order
No,
prohibits.
but whether to that aspect this court will
Because
go.
we are linked to the suit land through this suit, through their suit which we filed against them,
No, but in this case,
my lord.
the question is very limited
Yes,
question.
limited.
We cannot go into the other aspects.
That's why I prefer only calling for the scan copy, my lord, if lordship.
Yes, what is your submission?
They perhaps, my lord,
Lost-
misplace the file.
displace the file.
They don't have the file.
Okay, let us call. Heard Mr. S. Das, learned counsel for the petitioners. Also heard Miss, what is the name?
Yes, but
S. Paul, learned counsel for the respondents. For respondent number,
11, 12, 13, 14, 15, and 17.
लिख लो, 8. Whether service is
Yes,
complete.
yes, against the remaining respondents.
It appears that the service of notice in respect of other respondents is complete. Learned counsel for the petitioner has submitted that though the main contention in this CRPIO, in this civil revision petition, CRPIO is as to whether after passing of judgment, the trial court for correcting the contents of the judgment conduct an inquiry and exercise powers under section 152 of the Code of Civil Procedure to make changes in the judgment. However, he submits that since he submits that even for considering that issue under the facts and circumstances of this case, the scanned copy of the records of
Miss J case, my lord.
Ms. J case number
63 of 2020.
63 of 2022 would be required. Only Ms. J case will do
Yes, yes, the injunction
in connection with title suit number
79 of
79 of 2022 from the Court of Learned
Munshi Bongaigaon.
Munsif Bongaigaon. Stop. Let the aforesaid records, scan copy of the aforesaid records be called for. Registry to issue requisition for registry to take steps for requisitioning the aforesaid scan copy. List this matter
After vacation.
in the month of January after receipt of the scan copy.
Item 6. This is statutory appeal, my lord. The record has been received, my lord, so it will go for hearing, my lord. Yes, testamentary appeal.
The service,
Service completed, my lord. There are two respondents.
no, the notice, the office note says that on respondent number 2 could not be served. So
Then
on
we have to take
respondent
fresh
number
steps.
2, you have to take place. Heard Mr. S. Das, learned counsel for the petitioner. None has appeared for respondent number 1. The office note dated 2011-2025 shows that the notice issued to respondent number 2 would not be served as the addressee could not be located in the given address. Records were called for on
Record is there, my lord. Costley source, my lord, record is there.
the records requisition from the trial court has already been received. However, in view of the office note dated 2011-2025, the petitioner, the appellant is directed to take fresh steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List
Value.
according.
Value.
Pass over the matter for the time being, Lordship. As my senior was dragged into another court.
I give it to your lordship, my lord.
After some time, Lordship.
Who is your senior?
PHO.
Okay, we'll take it up after some time
Be at 2 months in that case, my lord.
at 2 p.m.
Before 2, Lordship. Because my senior is in another matter.
After, let it be after certain.
After some time.
Okay, after some time. Yes.
Yes, my lord, I had filed an IA. I'm the informant, lordship. Yes. Wherein there are two,
Item number 9 is the I. In item number 8. What is item number 8? I is in connection with item number 9.
item number 8, lordship, here I received the notice wherein I have filed my objection. I am the informant and this bail application, item number 8 was filed. Lordship can make a page 16, lordship. Item number 8 was filed in the IA, lordship, especially I would just want to project that. It was filed on 17/6.
No, I is in connection
Yes.
with item number 9.
Here petitioner is not there, petitioner's counsel. In item 8, I am the respondent because I am respondent number 2 in that and I have filed my objection.
In item number 8 and 9, there are 2 separate counsels for petitioner.
Yes, lordship.
Okay. What is the story? What happens?
Story is, lordship, item number 8 was filed on 17/6/2025. And subsequently, in the same FIR, another bail application was filed on 22/7/2025.
Item number 8 was filed on
It was filed on 17/6/2025. Means 2025 on the June, 17th of June.
And the next item,
was filed on 22nd of July, Lordship. While suppressing, this application was pending wherein respondent number 2 duly received the notice from the police station and she has filed her objection. But this bail application, she was not aware, she has not received any notice. But this honorable court has appointed amicus and accordingly, he was granted bail on 25/9, Lordship.
in which case?
In the subsequent case, bail application.
Which
uh,
one?
item number 9. In item number 9, he got bail
Okay.
by order dated 25/9/2025. While the first bail application was pending before this honorable court.
So your prayer is that suppression of
Yes, Lordship.
facts was there.
Just
And
separation of facts was there, and this is the reason, and there is, after he is out on bail, then also stalking is there. So,
And this bail application, let us take item number 8 first. 8, there was a prayer for withdrawal.
yes, Lordship, because this, they got bail, so this is the telling, submission before this honorable court was that a matter infructuous. Because already.
Because already he got bail in the other.
Yes, in the other case, suppressing this, because this was pending before this honorable court. Suppressing.
Yes,
this
what
was-
is your submission? Petitioner's submission in item number 8. Who is appearing for the petitioner?
For the respondent, I'm respondent, and I'm the applicant.
No one is appearing for petitioner.
So MS, name is shown, Lordship, MS.
Yes, Lordship. On the last occasion also, they appeared, Lordship. And Lordship has given them direction to seek instruction, Lordship, whether they need to appear in item number 9 also as well.
And one more aspect is, Lordship, if Lordship proceeds in the matter, Lordship, then probably Lordship, the second bail application, which was at a later point of time, their counsel also has to be put into notice, Lordship. Because,
I have taken steps.
because Lordship, the first, this is the prior one, Lordship. The second one where he got bail, Lordship, it was filed subsequently. So the counsels are different. So they also need to appear, Lordship.
Lordship, I have taken steps for in the IA.
Record to take.
Utul.
Maybe the record also needs to
I
be.
think record also is taken. Check. Office to record that I said, disposed of. Yeah,
Oh, sir.
record is there. And in fact, the council also knows about it.
That is why, Lordship.
Council, the second bail application council also is aware about this IA.
No, registry was directed to place the track consignment report. You have taken steps by.
After the notice was issued, then only I have taken steps, Lordship. Notice was issued on 29/10, thereafter I have taken steps.
In second item. I heard Ms. D. Ghosh, learned counsel for the applicant. It appears that registry was directed by this court by its order dated 17/11/2025 to place the track consignment report of the notice issued to respondent number 2 by speed post. However, same is not done. The registry to comply with the order dated 17/11/2025 before the next date. We will list it again in the next week and list the matter again at the date due. On 17th of
Can it be on 15th, it's not inconvenient?
15th of December. 15th of December.
If you-
And item number 8 of the book. None has appeared for the petitioner on call. Mr. B. Sharma, learned counsel for the learned additional public prosecutor is present, as well as Ms. D. Ghosh, learned counsel for respondent number 2 is also present. Since since this bail application, though there was a prayer by the learned counsel for the petitioner, Miss A. Begum, on last occasion to allow the petitioner to withdraw the instant bail application. However, considering the fact that one interlocutory application number 1140/225/2025 is pending before the court, wherein prayer for cancellation of bail granted to the present petitioner in bail application number 2401/2025 has been made. This bail application is directed to be tagged with the aforesaid record, aforementioned interlocutory application on the next date fixed. List it again on 15/12/2020.
Sorry, Lordship, first time missed it. The second time application, Lordship. First bail application rejected by your Lordship. That rejection order I have any. This petitioner is behind the bar, Lordship, since 1st of July 2024. As on that, Lordship, almost 1.5 years, Lordship is behind the bar. And he has been charged, Lordship, under section 22C. And prosecution has already examined, Lordship, 6 witnesses out of 9 witnesses, Lordship. All these 6 witnesses, Lordship, including the informant, who is also police officer, Lordship. There is nothing to, Lordship, say that there is any chance of, Lordship, something in the second person. First thing. Second thing is that,
What is the date of your arrest?
1/7/2024.
What is the time that has lapsed since then, exact time?
Issue is that Lordship has earlier rejected that my application. Now, the only issue is that Lordship, the person who has been examined, their evidence, Lordship, doesn't show that this petitioner has, if are involved in this kind of offenses. The seizure witnesses, who, Lordship, they claim to be independent witnesses, they have, Lordship, even said that we are not present and we were called to the police station, we put our signature in some blank paper. First thing.
No. During pendency of the trial,
Yes.
can we examine the witness?
I'm not saying, Lordship, to go meticulously, Lordship, but only thing is that what I have seen, Lordship.
We'll fix it after 20 days. Let 6-month lapse. Yes, Mr. Sharma. In the first week of January, heard Mr. J. Kalita, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Let this matter be listed in the at the date there. By 7th of January, it will be over.
Yes.
Let this matter be listed. Date of arrest is 7th of January. 7th of January.
Oblige.
Can it be tomorrow, Lordship, if they are not appearing?
None has appeared. For the petitioner on call. Let this matter be listed day after tomorrow. Again. 10-12.
Order, item 14.
My pleasure, Your Lordship. Lordship, in this case, I was directed to take steps through paper publication about response number 5. Accordingly, I have taken this step and also filed the affidavit, Lordship. That is on record. And services company, Lordship, LCR also received.
Heard Mr. R. Sharma, learned counsel for the appellant. Also heard Ms. D.D. Burman appearing for respondent number 8, as well as Mr. S. Alim appearing for respondent number 1 and 2. Learned counsel for the appellant has submitted that in pursuant to the directions of this court, the appellant has taken steps for publication of the notice to respondent number 5 through paper publication and has submitted an affidavit in compliance to that effect. On perusal of the said affidavit, it appears that the notices are published in which newspaper? In the vernacular newspaper Neomaya Varta on 23/11/2025, showing the date of appearance as 13th November, and showing the date of appearance as 8th of November,
8th of December, Lordship.
8th of December 2024. That is today. Hence, the notices issued to respondent number 5 through substituted mode is held to be duly served. The records of the concerned MAC case has already been received from the concerned motor accident tribunal, and hence this matter is ready for hearing. List this matter for hearing after 4 days on a date to. Yes.
There is another appeal arising out of the same judgment. And from last occasion, it was directed to this matter along with that one.
MSc appeal. Learned counsel for the appellant, learned counsel for respondent number 1, 2, and 3 has submitted that there is another appeal, that is MSc appeal number 86/2019, which arose from the same judgment and award is pending before this court. And same may be tagged along with this record. The prayer is allowed. Registry is to place the records of MSc appeal number 86/2019 along with this appeal list according. Yes,
This is an application basically for enhancement of the award. So, Lordship may find the order in page 56. Important issue number 4 and 5. Whether the petitioner is entitled to the reliefs in particular and his compensation, it is at page 66.
page 66. What about,
Compensation was given 6 lakhs.
what is this PG case?
That is,
Power
my lord.
Power Grid, land was acquired by Power Grid purpose. So for compensation, the PG case was filed.
Whether this petition is under section 115 of the CPC is maintainable, my lord. Because this is the order, the judgment order passed by Indian, not Indian ordinary civil suit, my lord. That was the order passed in, judgment passed in miscellaneous PG case number 20 or 27, 17, arising out of an application filed under section 10 and 16(3) of the Indian Telegraph Act, my lord.
Under section
10 and 16,
Indian Telegraph Act.
16(3) of the Indian Telegraph Act, my lord. So the petition of been filed under Article 227, my lord, not in under section 115, my lord.
Can we treat it as an application under 227?
That can be, that can be.
Section 115 petition is maintainable also in this case.
Okay.
I have some judgment of this honorable, the honorable Supreme Court. So I'm forwarding it to your lordship.
No, why this PG case was filed?
PG Power Grid, my lord.
Case was filed under Telegraph Act.
Telegraph Act, my lord. Under
Under
section 10 and 16(3), my lord.
10 in
16(3). For enhancement of the compensation, my lord.
So Power Grid Telegraph Department
Right.
puts lines and posts over your land. So for that, some compensation is,
That-
who award the compensation at the initial stage?
Initially, my this have the local revenue authority, my lord, they assess the compensation, my lord. If they are the compensation assessed by the local revenue authorities, they are not satisfied, they can approach the land decision, my lord, for enhancement of the compensation, my lord, under section 6(3). That is the provision, statutory provision, my lord.
So this,
This is 1976. 1976, 4 SCC 634.
just a minute, let me So on what basis compensation is assessed under this?
That is basis
Law.
of compensation for surface, for causing surface damage, my lord. The ownership of the land that remains with the petitioner, my lord. We are required to pay the compensation for the causing surface damage.
Our claim is at page 21 of the petition. On what basis we are making the entire claim? It's 3 crore 47 lakhs, 3 crore 23 lakhs. And only 6 lakhs, 86,000 was paid, given as compensation.
That is the learning.
It would require a lengthy hearing.
My lord.
So today is fixed for admission also.
Then we'll admit it if you satisfy that 115 is
Yes, sir.
maintainable.
Paragraph 20, I have just forwarded that.
Yes.
The provisions in the Telegraph Act which contemplates determination by the district judge of payment of compensation payable under section 10 of the Act indicates that the district judge acts judicially as the court, where the statutes matter record for determination by a court of record with no further provision. The necessary application is that the court will determine the matter as a court. In the present case, the statute makes the reference to the district judge as the presiding judge and the district court of the district court. In many statutes, reference is made to the district judge under this particular title, while the intention is to refer to the court of district judge. The Telegraph Act in section 16 contains intrinsic evidence that the district judge is mentioned there as the court of district judge. Section 16(4) of the Telegraph Act requires the payment into the court of district judge such amount as the telegraph authority deems sufficient if any disputes arise as to the persons entitled to receive compensation. Again, in section 34 of the Telegraph Act, reference is made to payment of court fee and issue of process, both of which suggests that the ordinary machinery of a court of civil jurisdiction is being made available for the settlement of these disputes. Section 315 of the General Process Act states that the dispute in any act of the central legislature means the judge of a principal civil court of original jurisdiction other than the High Court and the exercise of its original civil jurisdiction, unless there is anything repugnant in the context. In the Telegraph Act, there is nothing in the context to suggest that the reference to the district judge is not intended to reference to the district court, which seems to be meaning implied by the definition applicable there. The district judge under the Telegraph Act acts as a civil court in dealing with applications under section 16 of the Telegraph Act. This is accordingly the provision of CPC the civil court.
And there is no
Secondly,
appeal provision under 6.
no, that appeal, that order is final, therefore I have to come for revision.
There is no
No
appeal,
appeal lies.
no appeal lies under 16(3).
The
And the
order
same
passed by the learning is the final order, my lord. There is no provision for preparing any appeal, my lord.
In one
Then
more.
you also-
Then revision may lie.
Right.
What is your basic objection?
Regarding
Why? Regarding maintainability of this?
That's, I leave it to your lordship, my lord.
Okay. Heard.
There was
Yes.
another judgment of Kerala High Court, just clearly written that section 115 is maintainable. I'm forwarding this.
Actually, that I had no occasion to go. Copy there. Full page, eh?
Kerala. Last one paragraph. Lord. Several cases were discussed in that case of different acts also, and ultimately in the last but one paragraph, lordship will find. For the above reason, I agree with Balakrishna Menon that an order passed under section 16 of the Telegraph Act is one passed by the ordinary civil court and in the set up of the Telegraph Act is liable to be revised by the High Court under section 115 CPC.
Okay, heard Mr. R. Sharma, learned counsel for the petitioner. Also heard Mr. N.C. Das, learned senior counsel assisted by Mr. A. Das, learned counsel for the respondents, all the respondents. Respondents. This application under section 115 of the Code of Civil Procedure has been filed by the petitioners impugning the judgment and order dated 18/1/2023 passed by the Court of Learned Additional District Judge Hailakandi in Miss within bracket PG case number 20/2017 under section 10 and 16 of the Indian Telegraphs Act 1885, read with section 42 of the Electricity Act 1948. The petitioner is basically aggrieved with the quantum of the compensation awarded to them under section 10 of the Indian Telegraph Act 1885 by the telegraph authorities. Learned senior counsel for the petitioner, he raised an issue of maintainability of the revision, present revision petition under section 115 of the Code of Civil Procedure 1908. So learned counsel for the petitioner, on the other hand, submits that while dealing with an application under section 16 of the Indian Telegraphs Act 1885, the Court of District Judge acts primarily as a civil court, and as such, the provision of the Code of Civil Procedure is applicable to the said order. He further submits that as the order passed under section 16 within bracket clause 3 is a final order and no appeal is there, no appeal lies against the said order, a revision under section 115 of the Code of Civil Procedure is maintainable. In support of his submissions, learned counsel for the petitioner has cited a ruling of the Apex Court in the case of the Kerala State Electricity Board, Trivandrum versus TP Kunhali Umma, KUNHALIUMMA, reported in 1977 AIRSC 282, as well as another ruling of the High Court of Kerala in the case of Kerala State Electricity Board versus Cherian Varghese, reported in 1989 1 Kerala LJ 354. Stop. After considering the submissions made by learned counsel for the petitioners, as well as going through the rulings cited by him, this court is convinced, this court is of the by him, this court is of the view that as the Apex Court has held in the case of Kerala Electricity Board Trivandrum versus TP Kunhali Umma within bracket Supra, that a district judge, while dealing with an application under section 16 of the Telegraph Act, act as a civil court, and therefore the provisions of CPC is applicable to the said to any such order passed by the district judge. And as the order under section 16 clause 3 is a final order against which no appeal lies, the revision under section 115 of CPC is maintainable against such an order. Accordingly, this appeal is admitted for hearing. Sorry, accordingly, this revision is admitted for hearing. The records have arrived. Let the records of Miss PG case number 20/2017 be requisitioned from the concerned trial court registry to take steps for the same. List this matter for hearing after receipt of the records.
Okay. 14, 15, item 15.
We took right.
Exactly, your lord. My lord, I have taken steps for service of notice upon respondent number 1A, 1B, 1C. 1A and 1C, my lord. Today itself, my
Today,
lordship.
only one BNC application.
We already refused. We didn't service.
আমি কারণে চাইবো।
why today? You were directed to take steps.
But my lord, it is out of my sight, my lord, and that's today itself I have taken by registered post as well as legal process.
One BNC.
One BNC. One BNC.
Lordship, I am appearing for one BNC.
The respondent is the serial number 1A within bracket my lord Roman 1. And 1A Roman 3 my. If your lordship, kindly come to 47 minutes, then it will clear my. Otherwise there will 47 minutes. Kindly come.
খিলিমিলি কি আছে স্যার? মই সমীৰণ আৰু হেৰি
1A,
It is not 1C.
1A Roman 3 mile. Roman 3. It is-
But the direction was to take steps for 1AC.
Yes,
It was wrong direction.
not actually wrong, my lord. Honorable court has done no wrong, my lord. It is, my lord,
Was it a mistake?
yes. 1A Roman 1, 1A Roman 3. Instead of Roman 1C and 1A. Otherwise, my lord, 1B and 1C. They have, my land.
Lordship, I am appearing for Samiran Chakrabarti and Binapani Chakrabarti.
Yes,
Okay.
Lordship, may kindly come to page number 2, Lordship. I think there is some mistake with the numbering, Lordship. That is why the office note is written like that. গোটেই 1ABC লিখে আকর্ষণ BC লিখছে এখানে গন্ডগোল হচ্ছে।
that's why I am clearing.
Yes, Lordship.
Your part is clear, no problem.
Page number?
Page number 2, Lordship.
In your memo of appeal, you have mentioned who is 1A
Lordship, I am appearing for Samiran Chakrabarti and Binapani Chakrabarti.
One B and one C, my lord.
One B and one C. So one A, B, one A and one C, you have to take steps.
Yes, I have taken my.
Okay. Heard Mr. T.U. Loskar, learned counsel for the appellant. Also heard Miss. This is item number,
15.
Miss A. F. Ahmed. Learned counsel for respondent number. Yes, you are appearing for respondent number.
One B and C, Lordship, that is Samiran Chakrabarti and Binapani Chakrabarti.
One B and one C.
Lordship.
Though it appears that the appellant was directed to take steps way back on 19/8/2024 against respondent number 1A and 1C, however, learned counsel for the appellant submits that he has taken steps for issuance of notice upon the said respondents today only. Stop. In view of the submissions made by learned counsel for the appellant, await service report of notices issued to respondent number 1A and 1C. List this matter after 4 weeks.
Obliged.
Item 17. Item number 17.
None has appeared for the petitioner on call. On perusal of the records of this case,
Seventeen item number 7.
yes, what,
We could not contact with the petitioner lordship at this moment regarding service of dusty service lordship. At least sometime maybe granted lordship.
how many respondents are there?
3 respondents.
Heard Mr. R. Fukan, learned counsel for the petitioner, who submits that as he could not contact the petitioner regarding the fate of notice issued through dusty mode upon the respondents, some time may be granted to the petitioner for filing affidavit of compliance in respect of notices issued to respondents through dusty mode. The prayer is allowed. Let this matter be listed after 4 weeks.
But to take case steps lordship, respondents to restart post lordship.
Additionally, the petitioner is also allowed to take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Listed.
Obliged.
Lordship, kindly the matter may be taken up after some time. R. Chaudhary will appear, Lordship.
What is this?
Lordship, in this petition or before your lordship,
Why it is in the order column?
Lordship, we have taken step only under registered post and not in the usual process in that reflecting the office note. We may be allowed to take.
Any interim is there? Let them take steps. Heard Mr. L.R. Majumdar. You have taken steps by registered post.
Registered,
When?
it is 2022, Lordship.
Fresh steps, take fresh. Step. Heard Mr. L.R. Majumdar, learned counsel for the petitioner. Also heard Miss, what is your name? B. Hajorika appearing for Miss R. Chaudhary, learned counsel for the respondent number.
KVH, your lordship.
Give it in respect of which respondent?
Lordship, respondent number is there, respondent number 1 to 7,
In
8.
give it in slash respondent number 1 to 8. Learned counsel for the petitioner. Praise for allowing the petitioner to take fresh steps for issuance of notice upon respondent number 9 and 10 by speed force. The prayer is allowed. The petitioner shall take steps for issuance of notice upon respondent number 9 and 10 by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List according.
Maybe your lordship. The LCR was called for and it has come, my lord.
Ready for hearing.
No, my lord, it has to be admitted first. We'll let it come for admission, my lord. Notice was issued in this case.
Hmm. Who is appearing for the government?
SC Revenue, my lord. The name is reflected.
Heard Mr. A. Barkotaki, learned counsel for the petitioner. None has appeared for respondent side. The records of the trial court has arrived. Let this matter be listed in the admission column
After vacation, my lord.
in the month of January.
Much obliged. 46.
20 or 46. Yes, what is this?
The matter of lordship in compliance of the order dated on 11/9/2025, we have made part payment out of the 50% in compliance of order 41, rule 53C, your lordship. Yes. And on 23rd of October, the matter was listed. And we are supposed to file an affidavit bringing into record that we have paid our part regarding the decretal amount, your lordship. So on 7/11, we have submitted, being the appellant, we have submitted an additional affidavit bringing into record, lordship.
These interlocutory applications are for what?
610 for stay of the execution. And this honorable court was pleased to stay the impugned judgment and decree by on the ground that we are being the judgment letter supposed to submit 50%, and accordingly, out of my part, I have paid 25% of the decretal amount being the judgment, one of the judgment letter, your lordship.
And the two applications, there are two applications, 3414 and 3415, where we have prayed for striking out of the name of deceased respondent number 5, against whom for substitution of the legal heirs, we have filed 3 applications. One happened in this case, Your Lordship, when on first date of admission, notice was issued. On returnable date, it came to the knowledge of the appellant side that before filing of the appeal, the respondent number 5 expired. Accordingly, we have filed one application for impleadment of the legal heir that was withdrawn. Subsequent to that, we have filed 3 applications for substitution of the legal heirs, Your Lordship. Now, when this honorable court was pleased to issue notice upon the respondents or legal heirs, being the legal heirs of the respondent number 5, on perusal of the trial court record, what I have found that the respondent number 5, Your Lordship may kindly peruse IS Civil 3414 of 2025, Your Lordship. Para 7, Your Lordship. Page number 7, para 7. Where after going through the original case record of the title suit, what we found that respondent number 5 also, although submitted his wakalatnama, but he did not contest by filing his written statement either, or nor he adduced any evidence during trial, Your Lordship. So, as per the mandate of Order 22, Rule 4 CPC, if a party do not contest in the suit, so in that case, Your Lordship, the appellant or the plaintiff is not bound or is may not take substitute the legal heirs, Your Lordship. So, Your Lordship may kindly peruse the CPC, Your Lordship. Order 22, Rule 4, Sub-Rule 4, Your Lordship. Order 22, Rule 4, Sub-Rule 4.
Okay.
So in this connection, we have filed these 2 applications. One is praying for striking out of the name of the respondent number. This is respondent number 5. And another for withdrawal of the IAs that we have filed here. That will,
For substitution.
yes, Your Lord. 3 applications, Your Lord.
Okay. Who is appearing for other respondents?
Respondent number 7, 8, 9, Lordship, I am appearing.
How to verify that whether they have filed?
We have filed
You have filed an affidavit.
on 7/11. And I have the certified copy of the 11. Okay. Although it is a part of record, but
This RSA is for,
RSC will go for final hearing, Your Lordship, and these IAs are first to be disposed of. And in regarding the IA 1610 under Order 41, Rule 5, the stay is to be
no, before, let us take one by one. IA 3414. Where you have prayed for striking out the name of respondent number 5 on the ground that he did not contested the suit.
And in the appeal, we have under presumption he has appeared, so we made him a party in the appeal also. So at the second appeal stage, when I gone through the TCR record, there is an order reflecting to that, it is a part of the trial court record. I have mentioned the dates. But
What it says,
it says the respondent number 5 being the defendant number 1 is although filed his wakalatnama on 3/4/2013, after receipt of summons on 29/3/2013, although submitted but did not file any written statement or did not appear or adduced any evidence or faced any trial, Your Lordship.
Yes, you have anything to say?
I'm appearing for reference number 7, 8, and 9, Lordship.
No, their prayer is
Tracking.
for striking out the name. They are the appellant.
Whether the respondent number is a I with a necessary party, Lordship.
He was made as a defendant number 1. But if the party
Is the
doesn't
main
contest
party,
in the
Lordship.
suit, in the entire proceeding, a party doesn't contest in the suit, at this stage, you are not bound to substitute the legal heirs. It is as per the statutory provisions, Your Lordship.
Maybe like that's why not appeared.
That cannot be, Your Lordship. Your Lordship may go through the trial court record, Your Lordship. I request, Your Lordship.
When he died?
Died, Your Lordship, in the year 2022.
No, her prayer is not for striking out.
Tracking.
Two applications we have filed. He died in the year 2022. Prior to the filing of the second appeal, he was under the presumption that he appeared in the trial
Oh,
court.
Striking out prayer is not maintainable. Under Order 22, Rule 4, Subclause 4, the necessity of substituting is dispensed with. If he has not contested the suit, then you need not to substitute on his death in appeal. But that does not require striking out of his name. His name will remain there. But the legal heirs may not be brought on record.
I tracking out the name of respondent number.
That prayer is,
What happened in this case, Your Lordship, when we prepared the draft, as we have found his name in the, so we have made him a party.
no, we'll allow your second prayer. Say, you have filed one more IN. What is the number? 3415. 3414,
That is,
34, striking out prayer.
filed, he died in the year 2022 before filing of the second appeal, Your Lordship. And if he was that I'm not disputing, Your Lordship, but my submission is that he in the entire proceeding up to the trial title appellate stage, first appellate stage, he did not appear, or in the trial court, he did not contest in the suit, Your Lordship. Although he was made a party as defendant number 1 and hearing respondent number 5, Your Lordship.
Okay. Heard. Pratham I 3414. Heard, Miss, what is your name? Advance Gupta. Learned counsel for the applicant. Also heard Miss D.D. Burman. Learned counsel for respondent number 7, 8, and 9. And Mr. R. Board Pujari appearing for respondent number 10. And Mr. Dev Chaudhary, what is the initials? R.K. Dev Chaudhary. Learned SD, DSGY appearing for respondent number 11. this application under Order 1, Rule 10, so within bracket 2, read with section 151 of the Code of Civil Procedure, has been filed by the applicant/appellant in connection with regular second appeal number 86/2024, praying for striking out the name of respondent number 5, Mohammed Jamiruddin, who has already expired. The learned counsel for the applicant submits that on verification of the trial court records, it came to the notice of the appellant that though the respondent number 5 appeared before the trial court in the suit as defendant number 1 by filing wakalatnama, however, no written statement was filed by the said respondent/defendant. She further submits that there is nothing, the said respondent also did not adduce any evidence in defense, and there is nothing on record to indicate that apart from filing wakalatnama, he had contested the suit. She therefore submits that as Order 22, Rule 4, within bracket 4, exempt the plaintiff, enables the plaintiff, exempt the plaintiff from the necessity of substituting the legal representative of any such defendant who has failed to file written statement or had failed to contest the suit at hearing. She has prayed for striking out of the name of the state respondent from the memo of appeal. On the other hand, Ms. D.D. Burman Learned, Senior Additional Government Counsel, appearing for the state respondent, and other counsels appearing for remaining respondents have submitted that the prayer for striking out of name of the respondent number 5 may be considered only if this court comes to a conclusion that the state respondent is not a necessary party to the suit. And stop. I have considered the submissions made by learned counsel for both sides. It appears from the averments made in the instant interlocutory application that the prayer for striking out of name has been made. Name of the respondent number 5 has been made mainly on the ground that he did not file any written statement, nor he contested the suit by adducing any evidence. Hence, the provisions of Order 22, Rule 4 within bracket 4 of the CPC allows an exemption to the plaintiff/appellant from substituting the name of any such defendant on his death. it also appears that the present applicant has also filed an application and another interlocutory application numbered as IA 3415 2025, whereby the applicant has prayed for allowing him to withdraw the other three interlocutory applications which were filed by the said applicant, namely IA Civil 820/2020, IA Civil 819/2025, and IA Civil 3588/2024.
583 or
3583/2024, by which prayer for substituting the legal heirs of the deceased respondent number 5 was made. After considering the contentions of the counsel for the applicant in those in the said interlocutory application was allowed, and the petitioner was and the applicant was allowed to withdraw the instant those three interlocutory applications. As regards the instant prayer for instant interlocutory, as regards the prayer made in the instant interlocutory application regarding striking out of name of the defendant respondent number 5 from the memo of appeal is concerned. As this court may have to go into the question as whether the said defendant is a necessary party or not. The said prayer is not acceded to at this stage. More so, when the prayer for withdrawal, when the necessity of, when the prayer for exemption made by the applicant in other interlocutory application for necessity of substituting the legal heirs of respondent number 5 has been acceded to by this court. Hence, this interlocutory application is accordingly disposed of. In IA number 3415, this interlocutory application has been made by the applicant / appellant in connection with RSA number 86/2024, praying for allowing the petitioner, allowing the applicant to withdraw the IA number 820/2025, which was filed by the applicant for condoning the delay under Section 5 of the Limitation Act, for making prayer for setting aside of the abatement of the appeal against respondent number 5 on his death. So the applicant has also made prayer for withdrawing the interlocutory application number 819/2015, whereby the prayer for setting aside of abatement was made under Order 22 Rule 9 of the CPC by the applicant. The applicant has further prayed for allowing him to withdraw the IA Civil number 3583/2024, whereby prayer under Order 22 Rule 2 and 4 was made for allowing the substitution of the legal heir of respondent number 5 on his death. Learned counsel for the applicant has submitted that since it has come to the notice of the applicant/appellant that before the trial court, the respondent number 5 as defendant number 1 had appeared and filed in Wakalatnama. However, no written statement was filed by the said defendant. Neither any evidence was adduced in defense. And there is nothing to indicate that he had contested the suit in any manner. And therefore, she submits that the provision under Order 22 Rule 4, subclause 4 of the CPC allows the appellant to be exempted from the requirement of substituting the legal representative of any such respondent on death of such respondent. Stop. After considering the submissions made by learned counsel for the applicant, this court find force in the said submissions and accordingly allow the prayer for withdrawing the IA number 820/2025, IA number 819/2025 and IA number 3583/2024. Stop. This interlocutory application is accordingly disposed. Now in IA number 820, 819 and 3853 separate order ho etinita, similar order hobo, heard so and so and so. This interlocutory application is allowed to be withdrawn in terms of order dated 8/12/2025, passed in IA number 3415/2025. This interlocutory application accordingly dismissed on withdrawal. Now, what is there in the main suit?
In RSA.
Main RSA.
Your Lordship, while disposing by saying the impugned judgment, this honorable court was pleased to, as per order dated 11/9/2025, stay the impugned judgment and decree upon depositing of 50% of the decretal amount by joint judgment debtors. 2 judgment debtors are there. So I being the appellant, defendant number 3, I have paid my part and I have submitted the certified copy and I have even filed an additional affidavit. But regarding the part payment of the respondent number 6, I did not find anything in the record. So as per my knowledge,
Who is appearing for respondent number 6? Whether appearance is complete?
yes, appearance was completed. In the executing court, the date is fixed on 18th, Your Lordship, this month. So, Lordship, this IA and regarding payment part, can the matter be fixed in the month of January, Your Lordship? At least they may submit their 25% whether they have paid or not.
Which IA?
Actually, this order was passed in IA Civil 1610 and subsequently in RSA 86 of 2024, order dated 23/10/2025, Your Lordship, in the main RSA. And in IA, it is 1910, Your Lordship, or 11/9, Your Lordship, sorry.
One six one zero is disposed of.
Disposed of as per order dated 11/9/25, subject to the payment of 50%, Your Lordship. And in the main RSA, Lordship,
Now, in RSA, what is the status?
in RSA, appearance is complete by the respondent side.
It is ready for hearing.
Your
So we'll fix RSA for regular. And will when it can be heard,
Lordship,
till next date, we'll
yes, the stay actually was.
stay will be.
The impugned judgment, Your Lordship. Lordship may kindly peruse order dated 23/10/25, passed in the RSA, Your Lordship.
I bila kaji list hoise nahi. 3583. 3583. Okay. Monun. I number 3583, 1819 and 820. Item number 46 of the order. Huh? Heard in main RSA. RSA 86. Only RSA 86. Heard Miss S. Dasgupta or Baki Black as it is. By which this withdrawal prayer was allowed today.
3415.
3415. Stop. By an order passed today in interlocutory application number 3415/2025, the appellant was exempted from substituting the legal heirs of deceased respondent number 5 for the reasons stated in the said order. Stop. The appellant was also allowed to withdraw the interlocutory application number 3583/2024, IA number 819/2025 and IA number 820/2025. Learned counsel for the petition. Appellant has submitted that the that by order dated 11/9/2025 passed in I Civil number 1610/2024, the execution of the impugned decree was stayed during the pendency of the instant regular second appeal, subject to the condition of payment of 50% of the decretal amount by the present appellant as well as respondent number 6. Learned counsel for the petitioner submits that the present appellant has already deposited his share, that is 25% of the decretal amount. And to that effect, an additional affidavit has also been filed. She, however, submits that the respondent number 6 is yet to deposit.
But no order has been submitted before. As per my knowledge, your lordship,
No,
nothing has been submitted before this onward.
she further submits that though she has been informed that respondent number 6 has also deposited his share of the 25% of the decretal amount as directed by this court as a condition for stay of the execution of the impugned decree. However, no order to that effect or no document could yet be placed before this court. She therefore submits that some time may be granted. Time till next date may be granted. Who will produce that?
For the respondent 6.
Granted. Stop. So that the executing court does not proceed with the execution during the pendency of this case. None has appeared today for respondent number 6. Stop. Otherwise, this appeal is ready for hearing. Is it ready? Appeal is ready for hearing. And the records of the trial court as well as first appellate court has been received. Hence, let this matter be listed again in the first week of February. On the next date fixed, the respondent number 6 shall either submit an affidavit or show any shall submit an affidavit to show that he has complied with the order and complied with the directions given by this court for depositing his share of decretal amount as a condition for stay of execution of the decree during the pendency of the instant regular second appeal, list accordingly. The interim order of stay of execution of the decree, impugned decree, shall continue till next date. Item number 46 are with mix up of you all careful. Item number yes.
Lordship, as per office note dated 19/11/25 in IA number 2017/24, the steps have not been received by the registry, Lordship.
You are the applicant.
I am the appellant, Lordship.
Then what should we do? Dismiss this interlocutory application.
Lordship, direction for fresh steps may be given, Lordship.
Now, why have you not taken steps?
Lordship, some miscommunication was there, Lordship, so steps could not be taken.
Heard, Mr. What is your name?
A Singh, Lordship.
A Singh, learned counsel for the applicant. Also heard Mr. P.
Yeah.
A. Ahmed, learned counsel for respondent number
One.
1. This is respondent number 1. You are appearing for the legal heirs.
Not at all. I have
Respondent,
not received.
any instructions? Okay. It appears that by order dated 17/7/2024, the applicant was directed to take steps for issuance of notice upon the what is this interlocutory application?
Lordship, this IA number 2017 is for condonation of delay, Lordship, in preferring the substitution petition, Lordship. There has been a delay of 12 days.
Indicate last line. Upon the legal heirs of deceased respondent number 1. However, the counsel for the applicant submits that due to some miscommunication, the applicant could not take steps. He submits that he may be allowed one chance to take fresh steps for issuance of notice upon legal heirs of deceased respondent number 1. The prayer is allowed. The petitioner, the applicant shall take fresh steps for issuance of notice upon legal heirs of deceased respondent number 1 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
Lordship, respondent number 10 and 13 have also expired, Lordship. And accordingly, we have filed substitution petition also.
Which interlocutor?
IA number 1816, Lordship.
1816. Here also we have not taken steps.
So direction may be given, Lordship.
1816. Lawyer नाम है क्या लिखिबो? Other side नहीं लिखिबो. Learned counsel for the applicant submits that he could not take steps in pursuant to the directions of this court by order dated 5/8/2023 due to some miscommunication. He submits that the applicant may be allowed to take may be given one chance to take steps for issuance of notice on the respondents. The prayer is allowed. Issue notice. The petitioner shall take steps for issuance of notice by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. What are these other IAs?
The other IA is for setting aside amendment
These will come later on.
May I please order? As per office note dated 29/20/25, my lord. Respondent number 1 has already appeared, my lord. 2, my lord, received by son. 3, my lord, received by father, and 4, my lord, received by brother.
How many respondents are there?
My lord, total 4, my lord. 2, 3, 4, and my lord, same family. Yes.
Heard Mr. R. Sharma, Learned Counsel, appellant also heard Mr.
Yes, sir.
Jay Sharma appearing for
Respondent number 1.
Respondent number 1. On perusal of the office note dated 29/10/2024, it appears that the notice issued to respondent number 2, 3, and 4 have been received by the father, brother, and father, by the son, brother, father, and father, son, father, and brother of brother respectively of the said respondents. After perusal of the office notes, aforesaid office note, as well as the AD cards, the notices issued to aforesaid respondents are held to be duly served. The records of trial court as well as first appellate court have been received, and therefore this regular second appeal is ready for hearing. List it for hearing after 4 weeks on a date to be fixed by the registry. 4 weeks is usual course. 4 weeks. After 4 weeks is usual.
Usual?
You are enjoying any interim?
No, nothing. 4 weeks, my lord. And then 24.
With the lordship. In this case, as per office note, lordship, 1 to 3 already appeared and 4 died. So,
4 died.
yes, lordship. If
Then-
the 4 is pro forma, though the joint written statement was filed taking a stand that this is a joint property, lordship. Suit was for specific performance of contract. First appellate court held that this is not a joint property, so partition is not required. They have not filed any appeal challenging that lordship finding. But irrespective of all these, lordship, I want to implement them.
Okay. You
Yes, lordship, for abundant person, it is better.
heard
to-
Miss R. Chaudhary, Learned Counsel for the appellants. Also heard Mr. M. Alam appearing for respondent number
All respondents.
4 also.
1 to 3. lordship. Or it-
Respondent number 1 to 3. On perusal of the office note dated 10/11/2025, it appears that respondent number 4 has expired. Learned Counsel for the appellants submits that in view of the death of the respondent number 4, the appellants may be allowed some time to take appropriate steps for substituting the legal heirs / legal representatives of the deceased respondent. The prayer is allowed. Let this matter be listed after a
Directed to furnish the details of the legal heirs.
the Learned Counsel for the respondent number 1 to 3 has undertaken to furnish the details of legal representative of This is respondent number 4 to the learned counsel for the appellant within a week, within a week from the date of this order. Let this matter be listed after 4 weeks.
In IA 1874 and lordship, moreover in RSA, TCR received lordship. Both the record from both the courts received lordship, as per office net.
It also appears from the office note that the records of the first appellate court as well as trial court have been received. List accordingly. What is this IA?
IA 1874 is a stay petition lordship, by the order dated. It was state bill returnable date lordship, 14/10/2025. This is order 41 rule 5 petition lordship. Execution case is pending, so in paragraph 6, your lordship will find, however, in the.
Do you have any objection regarding this? We'll dispose of this IA. Giving stay during the pendency of the appeal.
Case number 5, lordship. In paragraph 6, it is reflected.
Heard Ms. R. Chaudhary, learned counsel for the applicant / appellant. Also heard Mr. M. Alamgir, learned counsel for the respondents, number 1, 2, and 3. It appears from here also respondent number 4 has expired.
Your lordship, yeah, it can be recorded as pro forma lordship. There is a direction to the plaintiff to deposit direction to the defendant to return back the amount which was given by the plaintiff. So execution has been stayed. In fact, our suit was dismissed. It was directed that the entire earnest money should be returned back to the plaintiff. Against that, we have filed the regular second appeal.
Okay.
We need the land, not the money.
slash appellant under order 39 rule 1 and 2. 39 rule 1 and 2. Praying for grant of temporary injunction, directing the respondents not to alienate, dispose of, or alter the nature and feature of the suit land during the pendency of the connected regular second appeal number 91/2025. Issue notice to the respondents. The petitioner, the applicant shall take steps for issuance of notice upon respondent by
One, two, three.
upon no
Lordship,
since Mr. What is the name? M. Alamgir. Since Mr. M. Alamgir has already appeared for respondent number 1, 2, and 3, no formal notice need to be issued against the said respondent. As regards respondent number 4, who is reported to have expired, the petitioner shall take appropriate steps in that regard. List this matter after 4 weeks.
This is an application under order 39, rule 1, 2, and 3, read with 151 of CPC.
1, 2, and 3 read with section 151.
Deeply obliged.
Yes. Yes.
Lordship, I am for respondent number 1, A, B, and C, and 2.
Who is for the appellant?
Her नाम show से cause mister. Oh, A Shishma.
None has appeared for the appellant.
Philanthrope.
You are for?
No, I think 25.
तुम्हाला काय आरोप में बेलेग respondent
Nine.
We are taking up item number?
25, Lordship.
Yes, you are.
Me to say yeah. Yes. For
For
the
the
res-
respondent.
Yes, Lordship.
Okay. None has appeared for the respondent on call. Miss,
Lordship, my name is not there, Lordship. SK I'm appearing for SK Ghosh.
F. Ahmed,
Yes, Lordship.
Mrs. F. Ahmed appearing for
SK Ghosh.
SK Ghosh Learned Council for respondent number
1, A, B, C, and 2.
1, A, B, C, and 2 is present. You are for?
Same respondent.
Same respondent. On perusal of the office note dated 3/11/2025, it appears that notice is issued to respondent number 4, 5, 6, 7, and 8 have been duly served. However, the respondent number 3 is shown to have been expired. In view of the aforesaid fact, the appellant may take appropriate steps in respect of respondent number 3. List this matter again after 2 weeks.
Lordship. Deeply obliged.
Item 26.
Hello, Mr. Mishra would be appearing online, my lord.
Mr. Fukon is there.
I beg to appear for respondent number 1, my lord, who's the claimant before the arbitrator. My lord had wanted me to be present physically, but my lord, I had also made my plans, but Indigo had other plans, my lord, so I couldn't come. I'm sorry, I joining through VC, my lord.
Okay, you raised the question.
I raised the question of maintainability, my lord.
Yes,
Well,
Mr. Mishra.
If your lordship, if your lordship will look at the order dated 24/11/2025,
Yes.
2710, my lord, first.
Yes.
The last part of the order, I have paragraph 7. And on the first, respondent number 1 has also raised question of maintainability of the instant revision petition in view of provision of section 16 of the Arbitration and Conciliation Act. Now, besides this, there is nothing on record as to what are the grounds on which the maintainability of this petition under 227 is being challenged. So I have no difficulty and I'll not seek for time. I can go ahead, but it is better if my learned friend can jot out, my lord, what are the grounds on which he is raising the point of maintainability.
So that
It
you
will
can-
be easier for me to reply.
Yes, Mr. Foucault.
My lord, I just need to show the judgments, my lord. And if your lordship wants me, I'll take your lordship briefly through the minimal facts, my lord, which are necessary for looking at the question of maintainability.
No, why don't you file an formal objection regarding maintainability so that something in writing also there will be there on record regarding,
My lord,
and it will be easier
I'll
for
just,
the
I'll just
easier
file.
for the other side to respond.
Well, then I'll file a preliminary reply, my lord, only on the question of maintainability, my lord, if your
Okay.
lordship permits me.
Okay. How much time will you take?
Your lordship, if I may only just point out that even the
When you will be visiting?
Well, at Guwahati, I'll be there in the first week, my lord. If it could be on the 5th or 7th, my lord. Well, before that, I'll file the reply, my lord, the affidavit.
It will be good.
I'll certainly be there, my lord. On the 5th, I can be there.
9 to 8.
Okay.
Lord,
Yes.
I'm very my lord, which did my learned friend, if it is my lord, hearing day, we'll be able to conclude on that day itself insofar as maintainability is concerned. Otherwise, if it comes on a miscellaneous day, it will reach my lord, sometime it reaches the last moment. If my lord can, subject to your lordship's convenience.
9th or 7th.
Well, at 7th, I would respectfully pray, my lord.
7th is Wednesday, my lord. It's a miscellaneous day.
Then 6th,
On
my
that
lord.
day,
6th
may not. If your lordship can take it up on 6th, 6th is Tuesday.
6th, okay, 6th.
Subject to that, my lord, your lordship's convenience.
Heard Mr. D.K. Mishra, Learned Senior Counsel, assisted by Mr. B. Prasad, Learned Counsel for the petitioner. Also heard Mr. A.K. Foucault, Learned Counsel for the respondent, who had earlier raised the question of maintainability of this CRPIO civil revision petition under Article 227 of the Constitution of India in view of the provisions contained in Section 16 of the Arbitration and Conciliation Act. Learned Senior Counsel for the respondent has submitted that apart from the oral plea as regards maintainability taken by Learned Counsel for the respondent, which has been reflected in the order dated 27/10/2025. There is nothing, in writing, on record, where in any plea regarding question of maintainability has been raised. He therefore submits that it would be convenient for the court as well as the respond, as well as the petitioners to respond the plea if same is put in writing. On this, the learned counsel for the respondent readily agreed to and prayed for allowing him to file a preliminary objection as regards the maintainability of the instant civil revision petition and prayed for some time for doing the same. The prayer is allowed. Let this matter be listed again on 6th of January as a fixed item to hear the question of maintainability. The respondent may file his written objection well in advance before the next fixed date with a advance copy of the same by furnishing an advance copy of the same to the learned counsel for the petitioner. If the said written objection is filed well in advance, it will also facilitate the petitioner to respond to the same in writing before the next date if they desire to do so. List accordingly on 6th January.
Deeply obliged. One was appearing for respondent number 1. Service on the other respondents is still awaited, my lord.
I'm appearing for 3, 4, and 5. I'll be filing my wakalatnama during the course of the day.
What is your name? How many respondents are there?
14.
What is your name?
A. Sandilya, my lord.
Mr. A. Shandilya, Learned Counsel for the Learned Counsel submits that he has been instructed by respondent number 3, 4, and 5 to appear on their behalf, and he would be filing his wakalatnama during the course of the day. As regards other respondents, you have taken steps through Dusty mode. You have to file an what has happened?
They notice. It has been delivered.
You file an
We'll file an
affidavit in compliance. Learned Counsel for the petitioner submits that as regards other respondents, the notice has been served on them through Dusty mode. However, he seeks some time to file an affidavit in compliance to that effect. The prayer is allowed. The petitioner may do so before the next date fixed.
Interim order, my
The interim order shall continue till next date.
Lordship, item 25, I was a lady.
I'm obliged, my lord.
Item 25. What is your name?
JP Borwa, well advised.
Show the name of Mr. JP Borwa. Show the presence of JP Borwa for appellant. You go through the order.
Item 27.
Next, my lord, as per office note dated 4/12/25, with regard to usual notice, my lord, no service report has been received, my lord. And with regard to register service, my lord, office note dated 23/7/25, unserved notice has been received, my lord. So maybe, my lord, I may be permitted to take dusty service. My lord. With regard
How many respondents
to
are there?
respondents.
Heard Mr. J. Deka.
TK Bhuya.
Yes, sorry, T.K. Bhuya, Learned Counsel for the applicants. This is delay condonation
Delay
application.
condonation.
Learned Counsel for the applicants. This is not delay condonation application.
191220, my lord.
1220 is stay application. condonation of the
1220, my lord, is
order.
order is, my lord, written in 1220, my lord, 1920. That is, my lord, 151 application.
1920, so. The order below multiple times.
1920 is, my lord, file under section 151 CPC, my lord.
Okay,
For day of the
okay,
execution.
1220 separately likhable. Separate. Or Mr. J. Deka, learned counsel for the applicant. Also, on perusal of the office note dated
It is 4/12/25.
there is no office note in this.
1220, there is a office. Yeah. 1220.
No office note.
Check Mara, sir.
Office note dated 4/12/2025 in IA number 1220/2025. It appears that notice is no service report has been received in respect of notices issued to respondent number 1 and 2. Learned counsel for the applicant has prayed for allowing the petitioner to allowing the applicant to take steps upon the respondents by way of dusty mode. The prayer is allowed. The petitioner applicant shall take steps within 7 days from the date of this order, returnable after 4 weeks. If the notices are served by way of dusty mode, the applicant shall file an affidavit of compliance thereto, list accordingly. In 1220, same order,
One, so, my lord, I am pressing the, my lord, this application, my lord, because, my lord, the respondent has already initiated the execution proceeding, my lord. There, I have filed an application to Captain Evans till the pendency of this, my lord, second appeal, my lord. That was, my lord, rejected.
but second appeal has not been
Not be
admitted.
rejected, my lord. That is why, my lord, in support of a decision of this honorable court, my lord, I am pressing this application.
What decision?
That during the pendency of the delay condonation application, my lord, under section 151, your lordship may have the power to stay the operation of this execution proceeding, my lord. It's paragraph 2, my lord. May I read, my lord?
But for that, notice has to be served,
My lord.
at least in delay condonation application also.
Lordship may observe, my lord, on the next date, my lord, that this application will be considered, my lord. Because, my lord, they are pressing in executing court, my lord. They have the knowledge about the pendency of this appeal, my lord, but they have not yet, my lord, appear in this case, my lord.
In 1220, or heard Mr. J. Deka, learned counsel for the applicants. It appears from office note dated 4/12/2025 that the notices, no service report has been received in respect of notices issued to respondent number 1 and 2. Learned counsel for the applicant has prayed for allowing the respondent to take steps for issuance of notice upon the aforesaid respondents by way of Dasti mode. The prayer is allowed. The petitioner shall take, the applicant shall take steps within 3 days from the date of this order, returnable after 15 days. No, returnable on 6th of January. 6th of January. Learned counsel for the petitioner has submitted that in the meanwhile, as the respondent have already initiated an execution proceeding which has been registered as title execution case number 2 of 19, same may be stayed till returnable date. He submits that even in an appropriate case, even during the pendency of an application for condonation of delay, the prayer for stay of execution may be considered by this court. And in support of his submission, he has cited a ruling of this court in the case of Ramesh Chandra Kalita versus Meera Patwari and others, reported in 1997, 1 GLR 287. Stop. Learned counsel, when is the date fixed for execution?
Yes, my lord, I have to check, my lord.
That will only show the urgency.
I am
If
giving, my lord.
date is mere, what is the stage of execution case?
Because, my lord, on last occasion, my lord, this honorable court has asked me to file an appropriate application before this, my lord, learned executive court, my lord. I have filed, my lord, but not state, my lord, this is for necessary order is like that, my lord.
Stop. Considering the above facts, till next returnable date, that is till 6th of January 2026, the execution of the impugned judgment and decree in the execution proceeding of title execution case number 2/2019 shall remain stayed. List accordingly.
TK where in place of, my lord, that account.
Oh, sorry, TK Bhuyan. Councilor Nam TK Bhuyan.
I'm getting.
28.
Your lordship. My lord, this is an application for condemnation of delay, lordship. There is a delay of 19 days, lordship.
I have
Any
no
objection?
My lord, already matter has been amicably settled between the parties, my lord.
Heard. Miss M. Chaudhary, learned counsel for the applicant. Also heard Mr. R. Borua, appearing for respondent number 1. Claimant.
Aye.
Respondent number 1, claimant. This application under section 5 of the Limitation Act 1963 has been filed by the appellant insurance company, praying for condoning the delay of 19 days in preferring the connected MAC appeal, whereby the judgment and award dated 31/12/2024 passed by the Motor Accident Claims Tribunal number 1, Kamrup Metro, in MAC case number 506/2020 has been impugned. Learned counsel for the petitioner has submitted that the petitioner has explained the reasons for approaching this court beyond the prescribed period of limitation in paragraph number 4 of the delay condonation application. On the other hand, learned counsel for the claimant respondent submits that considering the grounds as well as the fact that matter has that there is a possibility of amicable settlement between parties. He does not have any objection if the delay is condoned. Stop considering the submissions made by learned counsel for both sides, as well as considering the grounds stated in paragraph number 4 to be sufficient grounds which prevented the applicant insurance company in approaching this court by filing the connected MAC appeal within the prescribed period of limitation, the delay of 19 days in preferring the connected appeal is condoned, and this interlocutory application is allowed. The registry is directed to register the connected MAC appeal and list the same for admission.
My lord, in the local law,
Before the local adult,
coming 13,
13 days.
Before the
on coming 13.
before the ensuing Lok Adalat on 13th of December.
If
After applies,
the-
Lord.
applies.
My lord, these are appeals from, for enhancement of compensation for land acquisition. Judgment was of 2019. Appeal was preferred till date the original payment has not been paid, and in the meantime, one of the appellant died, my lord, for which two interlocutory applications have been filed. And today that may be disposed, my lord, and a direction may be issued to the respondents to pay the original awarded amount, my lord, by the reference court. Since 19 till now, not a single penny has been paid, my lord. Although there is no appeal preferred by the beneficiary from the respondent.
Is there any stay?
I am the claimant, my lord. I have preferred this writ appeal, the claimant for enhancement. Actually, in the year 2013, payment original.
What is the procedure if the respondent, does not pay the awarded amount?
MSC appeals, my lord, if for enhancement, the claimants come before this court, the insurance actually pays the amount. In fact,
No, you have to go for execution if there is no bar. Suppose they have not paid. There is a way out.
one direction would suffice, I think, my lord. Otherwise, the same thing would be, they are duty bound to pay as per the judgment. Just one direction, nothing else.
Yes, Mr. Dev Chaudhary, you are appearing for
I'm appealing for
insurance company.
it's a LA appeal.
Hmm.
Line equity.
It's a LA appeal.
Oh, sorry. 29.
Yes.
Then why don't you pay the undisputed amount?
Lordship, so far as we are concerned, Lordship, the amount has been disbursed to the Deputy Commissioner. Deputy Commissioner has to. And now already my friend is appearing in another case before the reference court, where there is a dispute between the beneficiaries themselves. That is fixed on
Regarding
20th.
regarding a
That
portion,
payment is not yet disbursed before the DC, my lord. Actually, what happened? In the year 2005 land.
No.
acquisition,
in this LA appeal, the issue is only regarding enhancement of the, there is no other issue.
No. Enhancement given by the district court. Original payment has been received. They have disbursed. Thereafter, I filed this 10 reference case before the district court under section 18 of Land Acquisition Act. There, my lord, further enhancement was already given. That amount has not been paid till now. In this court, I have sought other enhancement, my lord. That may, my lord, can you come to?
Beyond what, beyond,
Second stage of enhancement.
Yes,
you are agreed with the order of the reference court that
No.
the enhancement is not to the extent of your expectations. Therefore, okay.
so this undisputed first,
Then what is the mode? If suppose it is not paid,
my lord, this is a department, Defense Department of Union of India is involved.
no, what law
So-
prescribes? Is there some mechanism in law?
Land Acquisition Act, there is no specific, my lord.
So suppose they defy. If they don't pay,
If there is an appeal, so one direction would suffice, I think, my lord.
no, that I have understood. But my query is different.
Otherwise,
Yes, so worship, to my understanding, worship, when there's an award, like any other award, he has to get it executed.
Go for execution.
it's also one option, my lord. But other option is before your lordship.
Okay, let us take up the ayes.
Two, I for same person, my lord. Two land,
1483.
yes, that is land acquisition case, LA case number 10 of 19. There is no delay, no abatement. Within period, the interlocutory application had been filed. So that may be allowed. Appellant number 3 died, my lord.
Here you don't have any objection with it.
But on the last occasion, maybe the state needed some clarification. Oh, please.
On the last occasion, they said that after a long period, the appeal came, so they required additional copies. I already supplied them.
Heard Mr. D.K. Nath, learned counsel for the applicant in 1483. Learned counsel for the applicant. Also heard Miss B.D. Burman, learned additional senior government advocate appearing for respondent number 1, as well as Mr. R.K. Dev Chaudhary appearing for respondent number 2 and 3. Yes, Miss Burman, why don't you pay the enhanced amount? There is no stay. Okay. Learned counsel for learned counsel for respondent number 2 and 3. This application under order 22 rule 1 and 2 has been rule 1 and 2 of the Code of Civil Procedure 1908 has been filed by the appellants / applicant praying for allowing the substitution of legal representatives of appellant number 3 on his death on
22nd of March.
22nd March 2024. Learned counsel for the applicant submits that the present application has been filed within the period of limitation and the appellant number 3 died, leaving behind his wife and his wife Srimati Kamini Devi and his son Shri Jitul Sharma as his legal heirs. And therefore, the state legal heirs may be substituted in his place in the memo of appeal. The prayer is not objected to by the learned counsel for the respondents. Since the prayer for substitution has been made within the prescribed period of limitation after the death of respondent number 3, after the death of applicant number 3 on 22/3/2024, the prayer is allowed. The name of Srimati Kamini Devi and Shri Jitul Sharma shall be substituted as appellant number 3A and 3B in place of the deceased respondent in the memo of appeal. The in the name, in the place of the deceased respondent, deceased appellant number 3 in the memo of appeal. The appellant is directed to submit the amended false title of the memo of appeal within 7 days from the day of this order. This interlocutory application is accordingly disposed of. Next is
Same manner. The only LA case is different. 1481. That is LA appeal number 8 of 2019. Same person, manner. Appellant number 3, same order would go.
same order, only the LA appeal mentioning of LA appeal case number instead of 10. Instead of LA appeal 10, mention LA appeal number 8. Other
1483 is 10, 1481 is 8.
8. LA appeal number mention क्या है पहले?
Mistake in the,
But in the cause list it
Yes,
is.
but that is corrected, I think, in the title method of the file, not correct question. In the file, there is a correction already.
So then it has to come with item number, second interlocutory application has to come with item number 33. के साथ allowed. Then let this substitution be done. Let the rectified memo of appeal be filed.
Only in two cases substitution is there, other cases are already there. So let them
Other
take the
cases-
instruction,
Other cases are
take together,
Out of a common order.
take together, yes. It would one common order, madam. Let them take the instruction regarding the,
बाकी आता common order in otherwise this is ready for hearing. Service is complete.
yes.
Is that the okay?
Let them take the instruction. If they wills to pay, that would be very good, madam. Because otherwise the payment comes with interest, till payment.
No, they will pay. Otherwise you will have to go for execution.
That is what. He had immediately approached by filing a LA appeal. There was an enhancement by the reference court.
But he's agreed with the enhancement
Yes,
also.
We are in a fix also.
Okay, whether it may be enhanced.
Even if it is
They-
not enhanced,
no,
then
they-
also I am entitled to get that.
But they will pay you enhanced amount. Wait for some time.
Well, in this case, can the matter be disposed within a time frame, madam? That order maybe.
But this substitution business is not complete. Let it go.
Get it within 1 week done.
Okay, then we'll pass that order later on. Let the matter be listed after a week. In the first week of January.
Well.
After, in the third week of,
After
Oh.
19th.
after, let this matter be listed in the month of January after 19th of January. On a date to be fixed by registry.
Pay for at least one sentence that the payment is not yet been made, then I can even go for execution.
No,
That is always at liberty, lordship.
that observation is not necessary now.
In a particular case, lordship, what had happened was, reference court enhanced the compensation. I have paid it. Now, why the waiting business is there, I will just explain. What happens is, the land is acquired for the defense. Now, if I have to get the amount sanctioned from Delhi, it takes some time. The court observed that I will pay. I also agreed I will pay. It took around 6 months time because sanction and all coming. Another application is filed. Interest for this 6 months. Now that would be a never ending business. So let it finish first.
That would be also very good, but the problem is still since 2019, till we are in 2025.
But you got the original amount.
But-
Only enhanced amount you are not getting. So you can wait. I am not making any observation.
Now they are fighting between themselves in the reference court.
Apportionment.
So somebody
That is
says,
a different case, my lord.
no, regarding the same.
Not
Land.
same, not same.
Okay, let us see.
Okay.
Hmm.
49.
May I please lordships. The instant, my lord, I civil my lord filed my lord for restoration of the my lord RSM.
RSA was
RSM, my lord,
dismissed for
dismissed
default.
for default, my lord. So, dismissed for default was made on my lord.
And
18th
there was a delay in
My-
restoration
my
application.
lord,
This I is for
restoration of the for my lord, condoning the delay, my lord.
of 1,229 days.
My lord, it was not my lord, nor is my lord. When the my lord, the applicant, my lord, received a notice, my lord,
Mr.
from the
Ahmed, you are
executive court,
objecting.
my lord.
Will file objection.
You will file objection. Let him file objection.
Next time.
And, my lord, in the meantime, my lord, that my lord, executing court, my lord, the title execution case has been fixed on my lord 15/12, my lord. 15/12/2025, my lord. Just after week, my lord. After 1 week.
I regret to file
That's
because
why-
yesterday I received the correct copy of the condoning petition. After
Okay.
3 weeks, I file, my party will come from Calcutta. 3 weeks time again. Calcutta.
I would say, 2 weeks only.
No, I never.
My lord, 2 weeks if possible, my lord. Otherwise, my lord, that executing court, my lord, fixed for order, my lord, that matter, my lord. Otherwise, my
You
order.
convince the executing court
Yes.
that you have filed a petition. But no relief from this side. Heard Mr. K.U. Ahmed, learned counsel for the,
Yes, sir.
Yes,
sorry. Heard Mr. S. Ahmed, learned counsel for the applicant. Also heard Mr. J. Ahmed, learned counsel for
Full respondent.
all the respondents.
One respondent. One.
Learned counsel for the sole respondent. Sole respondent. Learned counsel for the respondent submits that as he has received the copy of application for condonation of delay under section 5
Right.
yesterday only,
Last right.
last Friday, he may be granted some time to file written objection against the prayer for condonation of delay. On the other hand, learned counsel for the applicant has submitted that the respondent has already filed an execution case before the executing court, and the said case is fixed for passing necessary order on 15th of December. In view of the same, what is your prayer?
2 weeks time, my lord.
3 weeks maybe. 3 weeks necessary.
6th December,
My lord.
6th of January.
January. I will do it. I will do it.
Obligement.
Considering the submissions made by learned counsel for the parties, the respondent is granted time till 6th of January for filing written objection against the instant interlocutory application. List accordingly on 6th of January.
Generally, we are not objecting, but 1,220, that is why I just file.
Obligement.
Yes.
Lordship, actually my health is not well since day before yesterday, Lordship. So I could not inform him as because his telephone number was not available with me. So I need few days, Lordship.
Okay. Heard, what is your name?
Sharma.
Heard Mr. U.B. Sharma, learned counsel for the applicant / appellant. Also heard Mr. A.R. Shom, learned counsel for respondents. Learned counsel for the applicant / appellant has prayed for an adjournment on the ground that he is not feeling well. The learned counsel for respondent does not opposes such the prayer for adjournment, hence same is allowed. Let this matter be listed after 2 weeks.
After vacation, Lordship.
After 19th of January,
Lord.
on a date to be fixed by registry.
What's it? Interim order may be continued.
The interim order shall continue till next day.
Hello.
Please, your lordship. However, my lord, notices may be issued. What has happened in this case, my lord? While disposing of the MSC appeal, my lord, the High Court has directed to pay an amount of 9,65,000. But for reasons based not known to them, my lord, they have only deposited 8,60,000, my lord. So filing this I, my lord, notices may, oh, my lord, they will
This I is for
payment of the remaining amount, my lord, actually, my lord. As per the order of this Court of Tamil, page 23, my lord, about total the remaining 9,65,000 was asked to be paid, my lord. But instead of that, my lord, they have deposited only 8,60,000, my lord.
what is the status of the appeal?
Appeal has been disposed of, my lord.
Okay.
While disposing of this, my lord, this.
Okay. Heard Mr. What is your name?
P. Sundi, my lord.
Heard Mr. P. Sundi, learned counsel for the applicant. This interlocutory application has been filed by the applicant. Applicant claimants.
Yes.
Claimants in connection with MSc appeal number 623/2018, which was disposed of by a coordinate bench of this court by
27/9/2020.
by judgment and order dated 27/9/2024. He submits that though by the said order, judgment and order, the insurance company was directed to pay an amount of pay a compensation of rupees 9,65,449 to the claimant/applicant. However, the insurance company has deposited an amount of only rupees
860059.
860059 before the registry.
Madam.
You have not withdrawn
Withdrawn, madam.
before the registry, which has been withdrawn by the present applicant. He submits that the insurance company may be directed to deposit the remaining amount of fees, 1,05,319 in terms of the order dated
27/9/24.
27/9/2024, passed in MEC appeal number
623 of 18.
623/2018. Stop. Issue notice to the respondents,
That's one day. So, madam.
to the respondent insurance company. The applicants shall take steps for issuance of notice by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
Much of.
42.
In this case, my lord, we have jointly filed a compromise. And my lord, been settled, my lord. We have filed a joint application, my lord. My lord.
Let it come up before on 13th. 13th before the Lok Adalat.
Settlement, and this can be disputed today itself. Just have to be decided to settle at rupees 12 lakhs.
Okay, okay. You are claimant applicant.
I'm the claimant for the insurance company, madam.
This was the appeal for enhancement.
Yes,
Yes,
madam.
sir.
What was the original award?
7,22,000.
What was the agreed amount?
Now
12
agreed
lakhs.
amount is 12 lakhs, my lord, with interest and all.
Heard Mr. P. Sundi, learned counsel for the applicant. Sole applicant,
Yes, madam.
also heard Mr. R. Goswami, learned counsel for the respondent insurance company. Number 3. In appeal. This interlocutory application has been registered on the basis of a joint compromise application filed by the appellant claimant and the insurance company / respondent number 3 in MEC appeal number 269/2019. 246/2019. The aforesaid appeal, the aforementioned appeal was preferred by the claimant appellant against the judgment and award dated 24/1/2019 passed by the Motor Accident Claims Tribunal, Sonitpur, in MEC case number
246.
246
So MSC case number is
339
39 of
39 of
2017 within bracket I. By the say impugn order, the appellant was granted a compensation amount of rupees, how much?
722,676.
722,676. And on being aggrieved by the quantum of the said compensation amount, the connected MAC appeal number 246/2019 has been preferred. Now, by this joint compromise petition, the insurance company and the appellant has agreed to amicably settle their claim at an agreed compensation amount of rupees 12 lakhs. As per the settlement arrived at between the parties, the insurance company shall pay an amount of rupees 12 lakh against the compensation, original compensation awarded to the claimant in MAC case number 339/2017.
39.
Only 13.
Only 39.
The said the instant compromise petition is supported by an affidavit sworn jointly by the manager of the New India Insurance Company Limited, Command Northeastern Regional Office, GS Road, and the appellant, Shri Mukunda Deka.
Babul second.
Appellant Babul second.
Babul second.
Sorry, appellant Babul Sekya.
Directed to deposit the amount before the registry within a particular time. 2 weeks. Is it?
Considering the submissions made by learned counsel for the applicant / appellant as well as the insurance company, and after going through the contents of the joint compromise application supported by affidavit filed by the respective parties, this interlocutory application is allowed and the MAC appeal number 246/2019 is disposed of in terms of the compromise arrived at between the parties. Stop. As per the settlement arrived at between the parties, the insurance company shall pay a sum of rupees 12 lakhs in all, which shall discharge the respondent insurance company of all liabilities in the said case. Stop. The insurance company is accordingly directed to deposit rupees 12 lakhs as enhanced compensation amount to be given to the registry of this court within a period of
4 weeks.
4 weeks from the date of this order. On deposit of the said amount, same shall be dispersed to the claimant appellant by the registry after proper verification. This interlocutory application is accordingly disposed of. In MSc appeal, heard party naam likhiyo, heard Mr. P. Sundi and Mr. R. Goswami. In terms of the orders, in terms of the order dated 8/12/2024, 5, passed in IS civil number 3676/2025. This appeal is disposed of on compromise.
But
Yes,
On the basis of last order passed by this honorable court, my lord, at order dated 24/6/2025, my lord. The matter was remanded before the learned trial court, first appellate court. Operative part of it. There are 19, my lord.
whether any report has come,
Yes, my lord. It is the record. On remand, my lord, plaintiff, present appellant and opponent, they adduce their evidences, my lord. When the appellant aggravated one document there.
No.
File of first appeal, in the appeal.
no. First appellate court, I know.
Record.
I to second appeal, original record, first appellate court,
Dangote.
original record. তার দুটা record আছে, trial court আর first appellate. Which one is the first appellate court?
Civil judge, my lord.
Civil judge? No.
Civil judge senior division highlight.
What is the submission?
Now, my lord. The paragraph 19, my lord. Additional issue was formulated by this honorable court, my lord, specific what would be the respective shares of the plaintiff and defendant number 1 and 5 and the pro forma defendants number 6 to 9 in respect of the suit length at 2 figures 80.
Maybe louder.
My lord, the additional issue was framed by this honorable court, my lord. In para 19, my lord, what would be the respective shares of the plaintiff? The defendants number 1 to 5 and the pro forma defendant numbers 9 to 6, 6 to 9 in respect of the suit length. That is 2 biga, 18 kathas and 6 chataks. It was remanded, my lord, by order dated 24/6/2025, my lord. On being remanded, my lord, the appellant adduced his evidence, my lord, which is the record, my lord.
Where is the finding?
Finding of the appellate court, my lord. On being remanded, my lord,
there is an order from the Lanet First Appellate Court.
Now, what was the finding of the appellate court, first appellate court? In the,
My lord, suit was filed by the
no, in respect of the additional issue.
petition issue, my lord. Sorry to submit, my lord, I could not go through my
Go through it,
lordship.
Mr. Kadir.
I also did not go. But I have instructed, my lord, as per issue framed by the Honorable Court, the First Appellate Court, my lord, decided the share of all of the, my lord.
No, then do you have any grievance?
No, no grievance. No grievance.
Let it be posted another time, and I have requested my senior, my lord, that it may post. I have not gone through. I have the evidences of my lord. Only one thing, on being remand, I have exhibited another, my lord, document, my lord.
No, the first appellate court, as per direction of this
My
court, has given a finding on the additional issues.
lord.
Now, do you have any submission to make on that? How will we deal with that additional issue? While deciding the regular second appeal before us. We will decide the substantial question of law only. In deciding the substantial question of law, what would be the impact of that additional issue? On that, you have to give assistance to this court.
In fact, my lord, both the certification of law already, my lord, carried by his Honorable Court, but order dated, my lord, 24/6/25. And after, my lord, finding that there is a certification of law, an additional issue is framed. And my friend has no objection on that, my lord, in framing the additional issue, and the matter was remanded back for.
Now, additional issue has been decided.
Decided, my lord, we have no grievance, and I think.
No, whether appellant has any grievance or not. Otherwise, we'll dispose it of.
Yes.
And let it be posted, my lord, on another time.
Okay.
Only issue was that, my lord, the earlier finding, my lord, decree was without following the order 20/18, my lord. And that was the only issue. The Lanet Trial Court did not, my lord, specify the share of the.
Now it has been specified.
Specified now.
So matter is
Matter is
finished.
Finished. There is nothing to
Only
go.
one thing, my lord, there is a
Still, you go through the record.
lodge.
Let him go through it. Heard Mr. J. Laskar, learned counsel for the appellant. Also heard Mr. M.Z. J. Kadir, learned counsel for the respondent. It appears that in terms of the order dated 24/6/2025, the Court of Learned Civil Judge Senior Division Hailakandi has decided the specific issue claimed by this court. And again, send the again send back the record of title appeal number 11/2015 along with the judgment dated 29/10/2025. Learned counsel for the appellant submits that he may be granted some time to go through the findings of the first appellate court on the specific additional issue framed by this court before he makes his submission. On the other hand, learned counsel for the respondent has submitted that as the first appellate court has complied with the directions of this court and has given its opinion on the respective shares of the plaintiffs and defendant number 1 to 5 and defendant number 6 to 9 in respect of the suit land. There remains no grievance amongst the parties. However, considering the submissions made by learned counsel for the appellant, let this matter be listed for hearing again on when?
After entering vacation.
Till 16 matter, my lord, my hand will go only the findings. So before vacation, if any day it's possible, my lord.
In the week commencing from 19th of January 2026.
Alright. 44.
Yes, please, Lord.
Now you have sufficient time.
My lord. Now, this case, the claim petition filed by the respondent number 1. Kindly see this my memo of appeal. MSC appeal 41 of the 23. Now, my lord, page number.
You are insurance company.
Yes, my. Now, kindly see the page number and annexure 2.
Why these IAs are?
They have withdrawn, IAS already stay was granted. This honorable court will continue. And kindly see this application was filed under section 166, page 24.
Yes.
Next, my lord, 25. It is a case of, my lord. It is a case registered 302/34 IPC. There is no rash and negligent. It is a murder case, my lord. It is a murder case. The fact is that murder is occurred, my lord, happened when this deceased person along with the demand was flying the vehicle, and some unknown person hired this vehicle for loading the goods, and on the way they killed them. That person killed the deceased person, the driver as well as the handyman. Then subsequently,
Who killed?
Some insurgent who hired this vehicle for loading the vehicle, goods. Only the intention to get this vehicle, to have the vehicle, to thief the vehicle. Then later on, this police has caught them and also registered the case 302 and 34 IPC. Then the file against that, they filed in 166. 166. That is why it is Australian coming. 166 and here. Then it's not maintainable. Then this, after trial, this trial court, Nogao, rejected the petition. But that judgment is, my lord, start from case 29. Because it is neither maintainable, 166 nor 163A. Because they also claim they got the salary of 4,000. If it is more than 40,000, they are not entitled. Because 162A, 63A is not maintainable, ultimately dismissed. This is Annexure 3, page 23, 9 onwards. And last page is, my lord, 40, the order of dismissal. Clearly, my lord, very specific judgment, there is no error in purpose. Page 40 is the findings of this learned tribunal. Against this, my lord, judgment, my lord claimant has filed this appeal before this honorable court.
Which appeal? This instant appeal.
No, earlier appeal. Next page, my lord. Page, kindly see annexure 41, page 41, the order. Order of this honorable court. After hearing the parties, this court, page 42 is the issues. Now, kindly, I read it with 2-3 page. Mr. I.A. Loskar, learned counsel for the science appeal and Archipel for the science. This is an appeal of science. On 26th, it is a, my lord, fact. Now this court might come on para 6. On the basis of the pleading of the party, the tribunal framed the following issues. Whether the claim is maintainable, whether the accident occurred due to rash and negligent driving of the driver of the vehicle bearing number so, whether the claimant is entitled to receive the compensation, and if so, through what action and liability claim, whether relief is sought for. Then the, my lord, this honorable court, second, paragraph 7, the claimants examined 3 witnesses. I also skipped up, and main is the paragraph 9. I have gone through, this honorable court has gone through anxious consideration to the submission made by the learned counsel, both the parties. Now the findings of this honorable court in Rita Devi Supra. Rita Devi Supra, the deceased was a driver of the auto risco. This is not an auto risco, which was used for hire by passenger, not a passenger. Some unknown passengers hired the auto risco, and therefore thereafter the dead body of the driver was discovered and the auto risco was missing. The Supreme Court has held that on the basis of the conjoint reading of section 163A1 and 163A2 is sufficient to hold that the legal heirs of the deceased are entitled to compensation for the insurance company, from the insurance company of the vehicle, because the death arose out of use of vehicle. Use of vehicle, my lord, Rita Devi, I am coming. Rita Devi, the case is 163A. It is 166. So, not complied with. Rita Devi cannot be taken into consideration this particular case. I am giving the Rita Devi judgment. Now, this in view of the law laid down Rita Devi, the view taken by the learned tribunal is found to be not sustainable in law. The claimants are entitled to get the compensation because of the death of the deceased. The appeal is allowed. Impugn order dated so-and-so pass in so-and-so MSC case is set aside. Case is remanded to the tribunal for passing fresh judgment in the light of the observation hearing. Now the question comes, the impugned judgment. I have come before this honorable court. Then this learned tribunal, on the basis of this order, by this remanded order, that this landed tribunal passed the judgment, my lord, pays start from, my lord, 12. 12. Everything is correct, but kindly see this. 21, page 21. Page 21, para 28. Page 21, para 28. At this stage, Mal got it?
Yes.
Yeah. At this stage, I deem it fit to apply the principle contained in section 4, reduced schedule 4 of Employees Compensation Act. This is the, my lord, jurisdictional error. How this MACT case, for deciding the compensation, that is the quantum, how it jumped to the WC court. Has jumped because he has not got any scope to decide the case on the basis of the Dita Devi. Dita Devi is the case of 163A. If it is a 163A, then question is, there is a no perversity because it is 166. There is a no rational negligence because it is a section under section 302(1) and also 34 IPC. Why there is a 279? There is nothing. So he has calculated the amount on the basis of WC Act. That cannot be. That cannot be. A number of judgment is there, honestly. In view of the matter, the appropriate factor, this is the first time I've got it. My lord, this is the first time I've got it. That cannot be calculated on the basis of the WC code. This is the MACT code has its own calculation on the basis of the salary on the into 12 months into factor like this. That is totally, my lord, erroneous. Then what has happened? 50% of the monthly income I have not found in a single judgment. FS court, our high court, and other court, this type of judgment. This is the first time I got it. That is why he has challenged. And also, then he has calculated 4,33,820. My question is that, my lord, and also he has calculated from the date of filing till the date of judgment, 12% interest, and he has given total rupees 20,70,000, 17,856. Totally erroneous, my lord, not maintainable. Because he ought to file this case, this type of case, either 163A, because there is a provision, either choice, either WC code or MACT code, 169 or MB Act or 168 MB Act. There is a choice, but that choice is, my lord, wrong, because it is a case of murder case. If it is, if they file 163A, would have maintained, but the first judgment is dismissed because of they said that he was earning rupees 4,000 into 12 into 48,000, because limitation of the 163A is 40,000. It should be below. That is also come to the finding of this landed first judgment. So that is a both sides calculated. Ultimately, court has no way, then ultimately dismiss the case. So after remand, he also done gross mistake, my lord.
No, the gross mistake according to you is done in computation of the,
Yes. Computation of the
according to
that cannot be.
employees compensation.
Yes, that cannot be.
But it may be under the formula laid down in Sarla Verma's case.
Now, from our case laid down, that is different. In the MACT note, it is a High Court, Supreme Court, as per the procedure, law laid down. It should be the amount, suppose income into 12 months, into factor, not factor, into, my lord, multiplier. That is nothing. It is a system, multiplier. Suppose if he is a 40 years old, 35 to 36 to 40, it will be 15 multiplier, supposing. Then my lord, he will get this future prospect also. If it is more less than 40 years, then he'll get the 40% future prospect accordingly.
Why multiplier effect system cannot be applied here?
No, here is not a multiplier question, not multiplier. It is a totally the quantum assessed by this learned tribunal, the assessed by the WC court. But it is not a case of WC court, it is a case of MACT court. MACT assessment of the quantum totally different than the, because WC court is given this, how to.
So what is your submission?
My submission is that, my lord, it is not a case of WC case, it is a case of MACT case. So the assessment of the learned trial, after remand trial court is totally erroneous, cannot be. So yeah, he may be allowed to file this appropriate forum. By that, he may be allowed for appropriate when he get the judgment, he go to the WC, that I can give, because one must not get any compensation. He must get, because there is a death. It is proof. That is proof. But they have selected the forum is totally wrong under section 166. This is the case. That is why my submission is better than the earlier judgment. Earlier judgment delivered by the first judgment, Learned Trial Court is very much clear.
No, but that was set aside by this court.
Set aside. Then when remand back, this honorable court has given one direction to follow the Rita Devi's case. Rita Devi's case, my lord, I'm giving the judgment. It is a case of 163A.
Motor vacancy.
So that is why, my lord, after remand, the Learned Tribunal is failed to accept the Rita Devi case. He jumped to the WC Compensation Act. How? I do not know how. So that. My lord, this is the case, my lord, headline. 163A, 167. Expression death. But this case was, my lord, murder case. Same case, murder case. Because that is an appropriate case in case of Rita Devi. Because it was murdered. Present case also murdered. 302. My lord, third line. 163 scope, murder when covered. This is because vehicle on the road is entitled. Because wrong filing by the claimant, not entitled. The claimant is suffering last 10 to 15 years. Wrong filing by the engaged counsel. Wrong quoting of the section. Because if it is Rita Devi case, also not maintainable. Because that is why the failed to appreciate Rita Devi case. I have impugned this before this honorable court, into judgment. There is no whisper, even the present judgment, regarding the Rita Devi's case. Can you see this other judgment? There is nowhere it is mentioned. Although this honorable court remand back, stating that to decide the case on the basis of the Rita Devi's case. That is why, my lord, he has come to the conclusion. He has calculated on the basis of the Workman Compensation Act. That Workman Compensation is a independent. This is the independent, my lord, status. The Motor Vehicle Act, there is a nowhere is mentioned to follow the while deciding the quantum on the basis of the WC case. There is no higher, I've gone through, my lord. I've not found even.
Read para 15.
No, 15 even then,
15 of Rita.
mentioned, they have mentioned, but ultimately overlooked. 15 coming to now the testimony of the.
No, 15 of Rita Devi.
Yes. Under counsel for the respondent, continuing the before. We find that the debt, the legal interpretation relied upon the, upon by us, and with the reference of the definition of what debt in the Workmen Compensation Act. The same will not be applicable while interpreting the word debt in the motor accident. In the Motor Vehicle Act will not be applicable while interpreting the word death in the Motor Vehicles Act, because according to her, the object of two acts are entirely different. Entirely different, madam. And she also contended that on the facts of the case, no proximity.
So your main submission is that the Motor Accident Claims Tribunal erred in
Signals.
computing the award
Quantum.
on the basis of Workmen Compensation Act.
Cannot be.
And in case of a murder,
Hmm.
an application under 166
not
is
maintained.
not maintainable.
Maintained.
These
Because-
are your two.
Yes, that is why lower court judgment, first judgment dismissed. They have already, the court has very vigorously written each and every aspect of the matter. The
And
lawsuit go through this judgment, and subsequently lawsuit has leads to send back, remand back, considering the case of Rita Devi. And Rita Devi's, my lord, case is very much, my lord, apparent. If they file 163A, isn't it? Because I also could not file this appeal also. Because 163 is murder case is applicable, because it is murder while in the vehicle on the road. Number of cases there. Rita Devi case, first page itself says that 163A, that is why this case was allowed. This case was allowed by the Honorable Supreme Court in the 2005.
now whether the present application under 166 can be treated as an application under 163A.
No, that is also, my lord, one judgment is there, cannot be converted.
Why?
My lord.
Okay, yes, Mr.
My
Talwar.
lord, I have our High Court order judgment
Regarding the
regarding
conversion,
the conversion. Once you file 166, that cannot be converted into, because why converted? Because if it is a 163A, my lord, see this, the amount he was getting per month, 4,000, it is admitted fact. If it is a 4,000, it will be 48,000. It will be more than 40,000. As per 163, it should be below, annual income should be below 40,000.
okay.
This is my case. Although, my lord, will not be remedial. So if he paid that, it may be liberty to file the case in appropriate forum. I have no objection even. They file, they give a liberty within a month, they file in appropriate forum. Will get the compensation. But it should be as per law. Law is violated. We are ready to pay if the WC court is awarded the amount. That can be because is with that case, my lord, one person is lost.
Yes, Mr. Talukdar.
Before my submission, I would like to point out the question raised by your lordship in para number 15 of the Rita Devi's judgment. In the Rita Devi's judgment, your lordship, last cite, a perusal of the object of the two enactments. A paragraph 15, last part of the paragraph. A perusal of the object of the two enactments clearly established that both the enactments are beneficial enactments operating in the same field. Hence, the judicially accepted interpretation of the word death in Work Compensation Act is, in our opinion, applicable to the interpretation of the word death in the Motor Vehicle Act also. Now, question of death is arised. Here, perhaps, if I am not mistaken to say, my learned colleague is unable to convince your lordship in respect of the question of death.
Death arising out of an accident.
The death arising out of the use and enjoyment of the vehicle. Your lordship is very much well aware that when the vehicle use and enjoyment of the vehicle, the question of evading the liability by the insurance company does not arise. Using and enjoying, my lord. In the present cases in hand, my lord, the accident took place on 26/3/2006. And due to the accident, my lord, the husband of the claimant number 3 and son of the claimant number 1 died. And the charge sheet was submitted by the police against the owner of the vehicle. And the driver of the vehicle. Now the question arises before our lordship is there. In the first case, the claim of the petition of the claimant was dismissed by the learned trial court. The claimant preferred an appeal before this honorable court. I pursued this appeal, my lord, and the honorable court was pleased to pass the order directing the learned trial court to decide as per the paragraph mentioned in the order in the said judgment, which my learned colleague already cited before your lordship.
Yes.
Now, on the basis of the judgment and as per the opinion as rendered by the apex court in respect of the Rita Devi, while the Rita Devi's case in 1994, while I was an advocate of Nagaland Bar Association, I was a witness also. Indirectly, I was a witness. And Rita Devi's case, judgment was passed by the learned member of the Motor Accident Tribunal, Dimapur. I was present at the time of hearing of this argument, fortunately. This case was dismissed by the Honorable Guwahati High Court in respect of death. Now the Supreme Court has upheld it, that the judgment passed by the tribunal is correct. Now in this Rita Devi judgment, the accident is the driver of the auto vehicle, with passenger he was driving, some miscreant snatched away vehicle and committed the murder of the driver. In my case, in the same case, same cause of action, my lord, only the date is different. In my case, some miscreant hired the auto rickshaw, pickup van, not auto rickshaw, my lord, pickup van, which was loaded with the vegetables. And they went in a forest area and they committed murder the driver and the son of the owner of the vehicle. But he was escaped somehow. He was also injured. But the driver committed murder. So this, when they have caught the driver
or the pickup van. At that time, the vehicle was used and enjoyment of the word used and enjoyment is a very important word in the judicial term in Motor Vehicle Act, my lord. Use and enjoyment of the vehicle. So now the question arises whether that person was a passenger of the vehicle. He was a passenger, man. He was in the vehicle. So accordingly, this claim petition, there is only fault on the part of this. The claim petition was filed before the Motor Accident Claims Tribunal. There are two alternatives. Your Lordship is very much well aware. One is Employees Compensation Act and one is Motor Vehicle Act. Now the claimant can take option either Motor Vehicle Act or the Employee Compensation Act. Now the present petitioner choose under 166 of the Motor Vehicle Act. Now what is happened? The learned court, trial court, initially it was dismissed. Later on, learned trial court passed the order in the light of the ratio laid down in section 4 of the Employees Compensation Act, which is, as per my view, I think, doubt my lord. The law is very, very clear. I doubt. Because very recently one judgment I have collected from Honorable Supreme Court. In this judgment, the judgment was passed by the trial court, and thereafter High Court reversed it under Workmen Compensation Act. And then this matter went to the Supreme Court. Supreme Court has reversed it. This is the judgment, a very recent judgment.
No, one of the submission is that in Rita Devi's case, the court held that the compensation application may be filed under section 163A.
My lord, 163, your lordship is very much well aware. 163A is a within 40,000 limits.
Yes.
There was a limit money.
So
Embargo created by the Honorable FS Court 40,000. 4,000, more than 4,000 if it is, then it is 48,000, my lord, it will crossed. So 48,000 cannot be exceeded 40. But later on it was withdrawn. Subsequent judgment it was withdrawn. But this judgment was not in my hand, but I have came across this judgment. Now, in my case is, my lord, 167, the petition was filed under 166 and 167. 166 is in respect of forum, which forum you want. Because anybody can choose any forum out of the two. Now, my question before your lordship is that once the learned tribunal committed error in law, whether we should be sufferer. When a court, knowingly or unknowingly, with due respect, when a court knowingly or unknowingly committed error in law, should be a sufferer? My question before this honorable court. I am a claimant. What I know, I know nothing. I know nothing. Whatever law has prescribed me, I will follow. Some discrepancy may be there, maybe bear right, my lord. But the judgment of the claim was filed under 166 of the Motor Vehicle Act, 167. Judgment was filed under section 4 of the Workmen Commission. This is a doubt. I respectfully agree. I respectfully agree. Being a long 35, 36 years practicing advocate, I cannot say dishonestly. That is why I leave it to your lordship to decide the destiny of the claimants. One already expired on 22nd, 2006. That is why, my lord. One already expired, father expired. Now mother is there, wife is there.
This is a positive submission last.
My 21 years is running, around 20 years is running this case.
I'm giving the liberty.
And perhaps this case was listed not less than 30 times. not less than perhaps 30 times, if I am not mistaken to say. That is why, my lord, there's a difference between.
And is there any stay?
My lord, stay. At the stay when he has filed this petition. At that time, it was granted stay. Thereafter, I filed petition for vacating the stay, but Honorable Court was not pleased upon me. That is why stay was not vacated.
Ultimately,
I
he has
tried my,
withdrawn.
thereafter I limit this petition. I didn't press the same. Because every Honorable Court has told me that the matter already fixed for hearing, LCR came and so.
Now, if you are admitting that the Motor Accident Claims Tribunal has committed an error by applying,
I'm in doubt. That is why what doubt I expressed.
might have committed an error,
My lord,
Might have.
my lord, this is
then what is your submission?
my submission. Your lordship has ample power under 173 of the Motor Vehicle Act to provide justice to the needy. That is my submission, my lord. To provide justice to the needy.
That is why, my lord, last submission is that second judgment also given, decided by this honorable court, because his original case is that 166. 166 means relation negligence has to be proved. 163A, not necessary. This is the fundamental of two sections. How it will be converted. That is why subsequent judgment are giving this. There is a three judgment. Justice leave judgment. That cannot be converted even then. Subsequently, one judgment is there. I have not got it. Justice Ansari judgment. At that time, 2008, that could be converted. But later on, it cannot be converted. Even Supreme Court says, because there is a fundamental is that 163A, 166 MB Act, there is a different thing. There is a two entity. Even then, MACT code and WC code there is a two different, my lord, code. So 163A MB Act need not require to prove the ration negligence. That is, you get the compensation. Directly you get the compensation.
My lord, Honorable Supreme Court has passed under 163A. This is the judgment passed on 163A.
That is why your case is 166.
163A. This was judgment also passed. 163 is a straight jacket formula.
Is, my lord, lower court file.
Straight jacket formula.
File 163A. That is why Supreme Court did not touch, because it is an appropriate case. But in your case, our case is the present case is that you file rightly, wrongly. I say wrongly file 166. Whether you have proved ration negligence. 166 is a fundamental to prove
My
the
lord,
ration.
if your lordship kindly go through the paragraph number 18 of Rita Devi, it will be clear.
Yes.
My lord, in the instant case, we have noticed the facts. We have no hesitation in coming to the conclusion that murder of the deceased Darshan Singh was due to accident arising out of the use of motor vehicle. In my case, same is there. Therefore, the trial court rightly came to the conclusion that the claimants were entitled for compensation as claimed by them, and the High Court was wrong in coming to the conclusion that Darshan Singh was not caused by an accident involving the use of motor vehicle. That is the different interpretation was used by the Honorable High Court.
That is why.
In my case,
that is why,
different interpretation cannot be taken.
Rita Devi's case. What is that? Rita Devi's case. This is my fair suggestion. Rita Devi initially filed 163A, but this High Court has something error. That is why go to the Supreme Court. The Supreme Court says that 163A and 166, there is a different entity. So that is why the Supreme Court says the High Court, Honorable High Court has done some purpose pending. So 163, my lord, I submitted. If it is filed, if he filed 163A, I could not file the case. Appeal. Because there is an option 167. Either go to the WC court or go to the MACT court. It is your choice. Now choice is yours. Your counsel has filed this case because claimant is don't know.
claimant does not know what counsel is doing. Now question that because of your erroneous, counsel done some error, now you are suffering. That is why first judgment passed by this learned tribunal, Nagaon, that is a dismiss. Subsequently, you file against the dismissal order, then remand back. Then remand back on the Rita Davis. Rita Davis is clearly says from the very beginning, claim petition was filed under section 163A. That
So is it your submission that the observations made by Apex
Yes.
Court in Rita Devi's case is
Yes.
not applicable to a case under
Yes.
166?
Yes. That is a two different entity. There is even
How but
how?
if you read section para 18 of the Rita Devi's case,
That is why what it said, para 18 says, the case filed by the claimant in the Rita Davis case, 163A. That is why the Supreme Court says the High Court has something wrong. High Court has done something wrong. Something wrong.
okay.
That is why the judgment was delivered by the Motor Accident Claims Tribunal is rightly, this is the right judgment. That is why Rita Davis went to the Supreme Court. Because it is allowed to the opposite party, the insurance company that whatever it may be, Bank of India, New India. So it will reverse the judgment on the High Court, possibly our High Court. That is why reverse the judgment of the trial court. Then Rita Davis went to the.
My lord, if your lordship kindly have a look of paragraph 14, then the answer will be there, my lord. My colleague's submission answer will be there in paragraph 14.
No. This is the Rita Davis case, facts and circumstances of the case. Otherwise, my
Answer
lord,
is there, my lord.
I have to read it the facts and circumstances. Under what section the Rita Davis filed the claim petition? 163A. Then judgment was allowed in favor of the Rita Davis. Then the insurance company filed the appeal, challenging the judgment and award. Then this honorable court, that honorable court, High Court, has reversed the judgment. That is why the findings. Otherwise, I have to go through the entire read it, Rita Davis case. Because
Okay. Okay, anything else?
that is how,
That
if it is,
my submission before your lordship. my lord.
because his remedy is that, my lord, I'm saying. So both the judgment, if I conclude both the judgment, first judgment and so second after remand judgment.
My judgment I referred, my lord, will be the best answer to
Okay.
decide by your lordship.
Which judgment?
This judgment I have given, Mohammed Masood purchased the New India Insurance
Our High
Company.
Court.
No, Supreme Court doesn't.
Okay, I see it. My lord, I have to, otherwise I have to go through the judgment. I have to give a reply. Go through. The question is that, my lord, Rita Davis-
Which para? Mohammed Masood, which para you are relying?
My lord, paragraph number.
Because
my
photo is
paragraph,
under what,
paragraph
section?
number 5, last part. Last part, page my lord, page 7. Page 7, my lord. The issue is stand answered by this court in Mostan and another Supra, which held that once the remedy under Motor Vehicle Act 88 was elected to be pursued by the claimant, my lord. And the tribunal educated the compensation by applying the criteria and fixing the income, falling back upon the parameters under the Workmen Compensation Act. Was not permissible.
Was not permissible.
The insurer could not have raised such a defense seeking to apply the provision of Workmen Compensation Act. Both the remedies are different.
This goes against you.
Yes.
Against you.
This goes against you.
But this plea was taken by the insurance company before the apex court, not by me. my lord.
That is why, what is the sum and substance of the case, actual situation of the case? You have to go through entire thing. Under what section you have filed and to get the.
Okay, Mr. Talukdar.
Yes.
If this court finds out that the Motor Accident Claims Tribunal erred in applying the provisions of Section 4 of the Workmen Compensation Act in computing the compensation. What is your submission? What is the remedy out?
I leave it before you.
No, but you, ultimate, everything will be done by the court, but you have to assist. What is yours?
I respectfully agree with you.
What is your submission under?
Honestly and fairly, not my submission. I think it will be wise on the part of this honorable court to decide whichever will be the best. Whichever will be the best.
Not maintainable.
Because the Motor Accident Claims Tribunal have no power to adjudicate under the Workmen Compensation Act. This is, there are some such
This is a my lord,
judgment are there.
jurisdictional error.
Okay.
So my lord, if it is.
No power.
That is why, my lord, I'm giving one submission for the benefit of the claimant. That if set aside the order and given the liberty to file an appropriate forum and appropriate case. So I think he will entertain the compensation.
Hmm.
That is why, my lord.
When the accident occurred, when the
My lord, accident occurred on 26/3/2006.
My lord. It is about
so already
20 years, about 20 years.
about 20 years
Yes.
have left.
Because of wrong proceeding by the Angus Council. Claimant is suffering. That is why my submission is.
Heard Mr. R.C. Paul, learned counsel for the appellant. Also heard Mr. A.R. Talukdar.
I.A. Talukdar.
Sorry. I.A. Talukdar, learned counsel for the respondent / claimant. Hearing concluded, judgment reserved.
My lord, one aspect I would like to put forward before your lordship. Since the witness already examined, witness part, every part is already examined. Now the only if your lordship refer the matter to Workmen Compensation Court and
No,
to
that
decide
cannot.
about the
Otherwise, you
compensation.
have to withdraw.
No, let him make his submission.
My lord,
No.
my lord, I will sit- I will
My lord, refer the matter to Workmen Compensation Court, decide the quantum of compensation, it will be sufficient, my lord.
That can-
Because my witness already examined, steps already be taken, judgment already passed, but only the quantum of compensation.
If it is, my lord, my last submission is that,
Hmm.
first of all, not maintainable. If it is not maintainable, only this court can be remand back to the MSCT court, because it is not a judgment of the workman compensation. Better you either lordship set aside the order and given the liberty, you file the workman compensation, will appear. Then even then we also give the amount very first day, because our amount is already calculated, 3 lakh something. Already calculated.
That is not the correct answer.
I don't
so
know,
far,
I
my
may,
my lord,
this is my submission,
your-
our submission.
the answer will be in with fairness, with due fairness, my lord.
What am I?
Already evidence already taken, everything was
Maybe
taken, but
it is-
the decision was not wrong as per the opinion of the honorable High
Claimant
Court.
has-
That is
it
why
is evidence in
honorable High
wrong
Court
forum.
referred the matter.
Wrong
And the
forum.
Workmen Compensation
Wrong forum.
passed the order.
How the wrong forum evidence record will come from the MSCT court knockout to MSCT, suppose workman compensation, can it be? They may say, because that is something else different. So that is why, my lord, my submission, last submission is that set aside the order and give a liberty to file an appropriate forum in appropriate section.
Okay, let me examine.
Yes, my
Wait for the judgment.
my lord, or otherwise my fixed for 11, if necessary, I'll give the 2.
Three times already judgment passed by the tribunal.
Parted, my lord, and give you one chance. I'll give you, I got a one judgment, 192 pages. How to decide the quantum in WCK and also MSCT code. That is why, give a one
This
week's time.
honorable court has came across a
That
thousand
is
of
why, I'm not
judgment.
going to, I'll have to, my lord.
No,
Sorry,
if I
other-
find some difficulty, I will come back to you again.
That is why, fixed another date, 1 week, I'll find out today itself. Then I'll also file. One date.
It is up to, I have no,
Parted
but
and
my
1 date.
submission is very quiet and very
Otherwise, just I'll
and
submit.
specific.
Nothing else,
Hmm.
more. Next week, my lord, or Tuesday or like.
It is very difficult to reach the item, my lord. Number of.
No, no, no,
practice
this
cases
is
will be
part
set.
hard and at 2 p.m.
It will be taken up as the
My lord.
fixed item.
Yes, fixed item at 2 p.m.
2 p.m.
Lordship,
Yes, my lord.
please, then I have no objection.
Yes. My lord, on
Heard,
16.
substantially heard.
16,
However,
Tuesday.
London counsel for the applicant submits that,
Appellant.
appellant submits that he may be allowed to place some authority in support of his submissions.
Part hard.
The prayer is allowed.
Part hard and fixed.
Let this matter be
16,
listed again on 16th
12,
12,
at 2 p.m.
2025 at 2 p.m.
My-
as
my lord,
part
my
of matter.
Much of that. My lord.
I'm wait, I
I'm
wait
sorry
before your